Introduction. Our civil code follows the Gaian order, which is of three parts: persons, things, and obligations. The title of Book 4 of the Civil Code is inaccurate. While the title is Obligations and Contracts, it should only be obligations, since by including contracts in the title, it is putting the latter on equal footing with the former, but this is not correct since contracts is only one of the sources of obligations. Obligations is the most important, most abstract, and most difficult of all of civil law. It is the entirety of private law. If you don't know obligations and contracts, you will never understand commercial law. The term obligations was derived from the words ob and ligare, which means to bind or tie together. Ligare is the source of several common words such as ligament and ligation. Ligation and vasectomy have the same purpose: to tie and to cut off, the fallopian tube, for the former, and the vas deferens, for the latter. Obligatio was initially a physical act of being chained, with shackles. Before, under Roman law, if the debtor cannot pay, the creditor can bring him to the magistrate, and the magistrate can authorize the creditor to cuff the debtor and offer him for sale for 3 days, the proceeds of which go to the creditor. The debtor then becomes a slave. If he is not bought, the creditor can have him chopped into little pieces or have him sold to the barbarians. As time passed, cruelty softened. By the time of Cicero, ligatio does not mean vinculum of chains but vinculum juris, bond of law. Obligation became metaphorical and not literal. Obligations. A definition of obligation. Art. 1156. An obligation is a juridical necessity to give, to do, or not to do. This provision is the soul of brevity. It was borrowed from Sanchez Roman. However, many commentators say it is incomplete because the obligation is only from the point of view of the debtor. To make it complete, it must cover the points of view of both the debtor and creditor. Obligations are bilateral. It should include what can be required, the remedy, and the means by which the creditor can take to pursue the remedy. An obligation is a juridical relation whereby a person should engage or refrain from engaging in a certain activity for the satisfaction of the private interest of another who, in the case of non-fulfillment of such duty, may obtain from the patrimony of the former through proper judicial proceedings the very prestation due or in default thereof, the economic equivalent that it represents, Diaz Piero. An obligation is a juridical relation whereby a person, called a creditor, may demand from another, called the debtor, the observance of a determinate conduct, and, in case of breach, may obtain satisfaction from the assets of the latter. Arias Ramos. B. Characteristics of obligations. 1. It represents an exclusively private interest. 2. It creates ties which are by nature transitory. Because obligations are extinguished, but the period is relative. Could be seconds, example buying Coke, and could be years, example partnership, lease. 3. It involves the power to make the juridical tie defective in case of non-fulfillment through satisfaction of the debtor's property. See trends in the modern law of obligations. 1. Progressive spiritualization of the law on obligations. Before, obligations were very formal and ritualistic. If it was not in the proper form, no obligations will assume. Now, the emphasis is in the meeting of the minds, and not on the specific form. There is even no need that it be in writing, as a general rule, since consensuality is the prevailing doctrine. As long as it can be manifest, and any kind of manifestation will do, it is sufficient. Roman law was formalistic. Vestiges of Roman law in the Civil Code can be seen in the law governing donations, which is very formal. Even for sales, the requirement of form is only for enforceability and not for validity. This is to make it conducive to business and facilitate commercial transactions. This is still an ongoing trend. E-commerce added another option in form and proof of contracts, but this is not applicable to all, usually only for business, not applicable to wills. 2. The principle of autonomy of will of the parties is now subject to several restrictions. While the principle still operates, the exceptions, prohibited areas, have grown larger and larger. Article 1306 gives the 5 restrictions, not contrary to law, morals, good customs, public order, or public policy. Those which are against these 5 restrictions are void, as can be seen in Article 1409. However, now we have restrictions such as social justice, environmental preservation, etc. This is because of the rising tide of social discontent, hence social legislation came to be for the underprivileged. 3. The mitigation of the principle that the debtor should answer with all his property. Before, the debtor had to answer his debts with all his property. Now, certain properties are exempt, and these can be found in substantive law, i.e., home, and in procedural law, i.e., support, etc. Also, the debtor may not be imprisoned for non-payment of debts. The theory is to leave the debtor something to live decently by. For the weakening of the principle that liability arises from responsibility. Art. 1409. The following contracts are inexistent and void from the beginning. 1. Those whose cause, object, or purpose is contrary to law, morals, good customs, public order or public policy. This is basically the principle in Quasi-Delicts. Now, in many cases, a person may be held liable even if not responsible. For example, under workmen's compensation, the employer is liable to compensate the employee even if the employer was not negligent. 5. The tendency of unity in modern legislation. This can be manifest in the rise of a global village. This can be seen particularly in trade laws. The tendency now is to make things uniform, especially in commerce. Different rules would impede commerce. D. Essential requisites of obligations. 1. Active subject. The active subject is called a creditor if the obligation is to give. The active subject is called an obligee if the obligation is to do. The active subject is always a person, whether juridical or natural. 2. Passive subject. The passive subject is called a debtor if the obligation is to give. The passive subject is called an obliger if the obligation is to do. The passive subject must be determinate or determinable. How can both subjects be determinate or determinable? A. Obligations where the subjects are completely and absolutely determined at the birth of an obligation. If A and B are parties to a contract of sale and B doesn't comply, A cannot sue C. A. Obligations where one subject is determined at the moment of the birth of the obligation and the other subject is to be determined subsequently at some fixed criterion, which criterion is fixed at the start of the obligation. B makes a promissory note payable to M or order. In this case, the creditor is not necessarily M. The creditor is either M or to whomever the promissory note is endorsed. At the time of the birth of the obligation, the payee is not yet known but the obligation is valid. B. Obligations in which subjects are determined in accordance with its relation to a thing, the real rights. A mortgaged property to X pursuant to a loan. The mortgage attaches to the property. If A sells the property to B, the annotation in the TCT will follow and B becomes the mortgager. If A doesn't pay, X goes against B. The obliger in this case is whoever owns the land. X doesn't care whether it's A or B. 3. Object of the obligation. The object of the obligation always consists in an activity or conduct to be observed by the debtor towards the creditor. This conduct to be observed is also known as the prestation. In a contract of sale, for example, the object of the obligation is the conduct of the vendor in delivering the car. The car, on the other hand, is the object of the prestation. Obligation. Sometimes, the commentators confuse the car as the object of the obligation, but this is wrong. The object is not the car but the prestation. According to Professor Balain, the distinction between the object of the obligation and the object of the prestation has been blurred by Articles 1347 to 1349. Requisites of the object of the obligation. A. Licit, legal. Example: can't validly enter into a contract for sexual services. B. Possible both in fact and in law. Determined by the rules of experience. C. Determinate or determinable. Can't say that, I promise to sell you something. Example of determinate, I promise to sell you my car. Example of determinable, I promise to sell you my Riceland in Bicol in November, will become determinate when time comes. D. Must have pecuniary value. For vinculum juris. The vinculum juris is the legal tie. It consists of the enforceability of the obligation. If the debtor does not conform, the creditor has the power to go to court to make the debtor perform, coercive. What makes an obligation is the power of the creditor to haul the debtor before the court, summoning powers of the state if needed. Voluntariness goes into entering into an obligation. But once you enter, it becomes involuntary. 5. Causa. Castan adds a fifth essential requisite, causa. Also known as causa debendi or causa obligations. Causa means the why of an obligation. The object of an obligation answers the question what is owed. Quid. The causa answers the question why is it owed. Cur. For example, A will deliver a car to B since A expects to get P300,000. The P300,000 is the causa of the obligation. 6. Form. Another commentators say that the sixth essential requisite is form. Form means some manifestation of intent. In some cases the manifestation is specific, such as in the case of donations. According to Professor Balain, that the general rule is that there is no specific form for a valid obligation. However, if form means that there is some external manifestation, fine, since we are not telepathic after all. However, there should still be no specific form. Sources of obligations, Article 1157, Art. 1157. Obligations arise from 1. Law. 2. Contracts. 3. Quasi-contracts. 4. Acts or omissions punished by law, and 5. Quasi-Delicts. There is really only one source of obligations, just law. Without the law saying that a particular contract is enforceable, the contract will not give rise to an obligation. However, source can be understood in both the ultimate and immediate sense. In the ultimate sense, law is the solitary source. In the immediate sense, there are 5, those enumerated in Article 1157. Law is therefore both an immediate and ultimate source. Examples of law being an immediate source are payment of taxes and accession. Is this enumeration of the sources of obligation exclusive? The Supreme Court in the case of Sagrada Orden vs. Nakako seemed to answer it in the affirmative. However, this is only by implication or indication. The court did not make an explicit statement that it is. Many commentators, including Professor Balain, believe that the list is not exclusive. They criticize the case because it is not a good way of enumerating. At present, there is one more possible source of obligations. Public offer. Example, in commercials, there is an offer to replace 30 sachets of Tide for 1 Venetian cut glass until the end of the year. There is no contract or quasi-contract. But if before the end of the year, you present your Tide sachets, you can demand for your glass. Public offer is in fact a source of obligation under the BGB, the German Civil Code, Article 657, which provides that a person who by public notice announces a reward in the performance of the act is liable even if such person did not act in view of such reward. Although public officers are supplemented by DTI regulations, Professor Balain thinks that public offer should be made part of the law since regulations easily change. 1. Law, Article 1158. Art. 1158 Obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable, and shall be regulated by the precepts of the law, which establishes them, and as to what has not been foreseen, by the provisions of this book. There is only one ultimate source of obligations, law. However, there are 5 proximate sources of obligations, Article 1157. 2. Contract, Article 1159. Art. 1159 Obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. Contract is only one of the sources of obligations. This provision combines 2 concepts of Roman law, equity or good faith, ius gentium, and strict compliance by the parties, ius cenial. A contract is a meeting of minds between 2 persons whereby one binds himself, with respect to the other, to give something or to render some service, Article 1305. Contractual obligations have the force of law between the contracting parties and should be complied with in good faith, Article 1159. The contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. Article 1306. Contracts are perfected by mere consent, and from that moment the parties are bound not only to the fulfillment of what has been expressly stipulated but also to all the consequences which, according to their nature, may be in keeping with good faith, usage, and law. Article 1315. In case of doubt, the interpretation consistent with good faith is followed, People's Car vs. Commando Security. Party cannot excuse themselves on the ground that it has become unprofitable. Law will not protect you from your own bad judgment. 3. Quasi-contract, Article 1160. Art. 1160 Obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 17, of this book. For delict, Article 1161. Art. 1161 Civil obligations arising from criminal offenses shall be governed by the penal laws, subject to the provisions of Article 2177, and of the pertinent provisions of Chapter 2, Preliminary Title, on Human Relations, and of Title 18 of this book, Regulating Damages. General Rule: if you commit a crime, you are liable both criminally and civilly. Exception: no private offended party, e.g. contempt, etc. The Civil Code deals with the civil aspect, i.e. indemnification for loss of earning capacity. 5. Quasi-Delict, Article 1162. Art. 1162 Obligations derived from quasi-delicts shall be governed by the provisions of Chapter 2, Title 17 of this book, and by special laws. Quasi-delict is a civil law term while tort is a common law term. Difference between contractual liability and quasi-delict. In quasi-delict, the obligation arises only when there is a violation. Without violation, there is no obligation. It is the breach itself which gives rise to the obligation. In contracts, there is already an obligation which exists prior to or even without a breach. The breach of the contract is immaterial to the legal obligation. Example: contract of sale of watch. If both parties perform their obligation, the contract is extinguished. There is no breach, but there is an obligation. Compare the above example with the one below. Example: driving recklessly, hits a child. When did the obligation came to being? When there was injury due to negligence. Negligence per se does not give rise to a quasi-delict unless there is injury. Breach and quasi-delict are inseparable. But contract and breach may be separable. Question: are contracts and quasi-delicts mutually exclusive? Answer: no. In Gutierrez vs. Gutierrez, there was a collision between a bus and a car and a passenger of the bus was injured. It was proven that the driver of the car was a minor and an incompetent driver. The passenger sued against them all. The Supreme Court held that the bus driver, bus owner, and the driver of the car, through his father, are jointly and severally liable to the passenger. The liability of the owner of the bus and the bus driver rests on that of a contract. On the other hand, the father is responsible for the acts of his son and is therefore responsible for the negligence of the minor. Here, it is clear that breach of contract and quasi-delict are separate. However, they can overlap, as can be seen in the following example. Bus driver drives recklessly and the bus hits a tree. A passenger is injured. The passenger and sue the driver for quasi-delict, due to negligence, or for crime, or the bus company for breach of contract of carriage, or for quasi-delict, negligence in the selection and supervision. The cause of action one chooses determines the one. Parties involved 2. Degree of proof 3. Defenses. One can tailor his suit depending on the cause of action he chooses. F. Nature and effect of obligations. 1. Kinds of prestations. A. To give, Articles 1163 to 1166. Art. 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. Art. 1164. The creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Art. 1165. When what is to be delivered is a determinate thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obliger delays, or has promised to deliver the same thing to 2 or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. Art. 1166. The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. I. To give a determinate thing. Primary obligation, giving what is supposed to be given. 3. Accessory obligations. 1. After constitution of the obligation and before delivery, to take care of it with the proper diligence of a good father of the family, Article 1163. General rule, diligence of a good father of the family. Exception, law or stipulation requires different standard of care. If through negligence, something causes the thing damage, the debtor is liable for damages. This is not applicable to a generic thing. 2. To account and deliver to the creditor the fruits if the thing bears fruits upon the time the obligation to deliver it arises. Article 1164. However, ownership is transferred only by delivery. Hence, creditor's right over the fruits is merely personal. Example, A sold B a mango plantation to be delivered on January 1st. Come January 1st, A did not deliver. A instead sold the fruits to C, a buyer in good faith. B sues A for specific performance. Court awards the plantation to B. Does B have a right to the fruits? Yes, as against A. No, as against C, because B's right over the fruits is only personal. B's remedy is to go against A for the value of the fruits. 3. To deliver the accessions and accessories, Article 1166. Don't take accession in the technical sense, or else, it might overlap with 2. Understand it to mean things that go with the thing to be delivered, i.e. radio of the car. Remedies available to the creditor. 1. Specific performance, the debtor must perform it personally. 2. Equivalent performance, damages. Damages may be obtained exclusively or in addition to the first action. Rules regarding improvement, loss, or deterioration. Articles 1189, 1190, 1194. Art. 1189. When the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. 1. If the thing is lost without the fault of the debtor, the obligation shall be extinguished. 2. If the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. 3. When the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. 4. If it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment, with indemnity for damages in either case. 5. If the thing is improved by its nature, or by time, the improvement shall inure to the benefit of the creditor. 6. If it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. Art. 1190. When the conditions have for their purpose the extinguishment of an obligation to give, the parties, upon the fulfillment of said conditions, shall return to each other what they have received. In case of the loss, deterioration, or improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. As for the obligations to do and not to do, the provisions of the second paragraph of Article 1187 shall be observed as regards the effect of the extinguishment of the obligation. Art. 1194. In case of loss, deterioration, or improvement of the thing before the arrival of the day certain, the rules in Article 1189 shall be observed. 1. Requisites. An obligation has a suspensive condition, a resolutory condition or term. B. The obliger is obligated to deliver a determinate thing. C. There is improvement, loss, or deterioration before the fulfillment of the condition or the period. D. The condition is fulfilled or the period arrives. 2. Rules proper. A. If the thing is lost without the fault of the debtor, the obligation is extinguished. B. If the thing is lost through the fault of the debtor, he must pay damages. The thing is lost when it perishes, goes out of commerce or disappears in such a way that its existence is unknown or cannot be recovered. C. If the thing deteriorates without the fault of the debtor, the creditor must accept the thing in its impaired condition. D. If the thing deteriorates through the fault of the debtor, the creditor may choose between irresolution, Article 1189, plus damages. 2. Fulfillment of the obligation plus damages. E. If the thing is improved by nature or by time, the improvement shall inure to the benefit of the creditor. F. If the thing is improved at the expense of the debtor shall the same rights as a usufructuary. 2. To give a generic thing. Remedies available to the creditor. 1. Specific performance, the debtor must perform it personally. 2. Substitute performance, done by someone else, perform at the expense of the debtor. 3. Equivalent performance, damages. Damages may be obtained exclusively or in addition to the first two actions. See to do, Article 1167. Art. 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. This same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. I. Only the obliger can do, personalissimo. Remedies available to the creditor. 1. Equivalent performances, damages. 2. Anyone else can do it, not personalissimo. Remedies available to the creditor. 1. Substitute performance, done by someone else, perform at the expense of the debtor. 2. Equivalent performance, damages. Damages may be obtained exclusively or in addition to the first two actions. B. Not to do, Article 1168. Art. 1168. When the obligation consists in not doing, and the obliger does what has been forbidden him, it shall also be undone at his expense. This includes the obligation not to give. Remedies available to the creditor. I substitute performance, done by someone else, perform at the expense of the debtor. 2 equivalent performance, damages. Damages may be obtained exclusively or in addition to the first 2 actions. Summary of the rules regarding remedies available to the creditor in obligations to give, to do, and not to do. Obligation. Specific performance. Equivalent performance. Substitute performance. 1 to give. A determinate thing. Square root. Square root. Times b determinable thing. Square root. Square root. Square root 2. To do. A very personal. Times. Square root. Times b. Not very personal. Times. Square root. Square root 3. Not to do. Times. Square root. Square root. Specific performance is the performance of the prestation itself. In obligations to do or not to do, specific performance is not available since it will go against the constitutional prohibition against involuntary servitude. Equivalent performance is the payment of damages. Substitute performance is when someone else performs or something else is performed at the expense of the debtor. 2 irregularity in performance. A attributable to the debtor, culpable. Article 1170 provides that those who in the performance of their obligations are guilty of fraud, negligence, or delay and those who in any manner contravene the tenor thereof, are liable for damages. According to Professor Balain, the phrase, who in any manner contravene the tenor thereof, is a catch-all provision. However, such is unnecessary. Nothing will escape fraud, negligence, or delay. I fraud, Articles 1170, 1171. Art. 1170 Those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof, are liable for damages. Art. 1171 Responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. The problem with fraud is the term. It is used in different meanings in the code. Fraud may be defined as the voluntary execution of a wrongful act, or willful omission, knowing and intending the effects which naturally and necessarily arise from such act or omission. Fraud is the deliberate and intentional evasion of the normal fulfillment of the obligation. It is distinguished from negligence by the presence of deliberate intent, which is lacking in the latter. Legaspi Oil vs. CA. Fraud under Article 1170 is more properly called as malice. Fraud under Article 1170 must not be confused with fraud under Article 1338. Fraud under Article 1338 is more properly called as deceit. In Article 1338, fraud pre-exists the obligation, thus the obligation is voidable. Deceit vitiates consent in contracts. Deceit is antecedent fraud. The deceit occurs by using insidious words machinations. Without this deceit, the other party would not have entered into the contract. In Article 1171, there was already an obligation before the fraud exists. Malice is subsequent fraud. Example of fraud is deceit under Article 1338. A and B entered into a contract of sale of a diamond necklace. However, the necklace was really made of glass. Fraud here is deceit. There was vitiation of consent, hence the contract is voidable. Example of fraud is malice under Article 1171. A and B entered into a contract. B will deliver furniture made of Nara but B delivered one made of plywood. Fraud here is malice. It will not affect the validity of the contract. Effects of fraud, Articles 1170, 1171. One creditor may insist on proper substitute or specific performance, Article 1233, or 2. Rescission/resolution, Article 1191, 3. Damages in either case, Article 1170, 2. Negligence. Negligence is the absence of due diligence, Article 1173, Art. 1173. The fault or negligence of the obliger consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time and of the place. When negligence shows bad faith, the provisions of Articles 1171 and 2201, paragraph 2, shall apply. Art. 1338. There is fraud when, through insidious words or machinations of one of the contracting parties, the other is induced to enter into a contract which, without them, he would not have agreed to. Art. 1233. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Art. 1191. The power to rescind obligations is implied in reciprocal ones, in case one of the obligers should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation, with the payment of damages in either case. He may also seek rescission, even after he has chosen fulfillment, if the latter should become impossible. The court shall decree the rescission claimed, unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third persons who have acquired the thing, in accordance with Articles 1385 and 1388 and the mortgage law. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. Art. 1172. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts, according to the circumstances. Like fraud, negligence results in improper performance. But it is characterized by lack of care, unlike fraud which is characterized by malice. Lack of care means lack of due diligence or the care of a good father of the family, bonus pater familias, under Article 1163. In English law, due diligence is called the diligence of a prudent businessman, since they are more commerce-oriented. Two types of negligence: 1. Simple. 2. Gross. The determination of due diligence is always relative. It will depend on 1. The nature of the obligation. 2. Nature of the circumstances of a person. B times C place. Example: the diligence required in shipping hinges is different from the diligence required in shipping the Pieta di Michelangelo. The shipper must observe the diligence of a good father of the family in both cases, but the standard of care is different. It is much higher for the Pieta. The diligence of a good father of the family is the imaginary standard. Effects of negligence, Articles 1170, 1172. 1. Creditor may insist on proper substitute or specific performance, Article 1233, or 2. Rescission/resolution, Article 1191, 3. Damages in either case, Article 1170. 3. Delay, mora. Art. 1169. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary in order that delay may exist. 1. When the obligation or the law expressly so declare, or 2. When from the nature and the circumstances of the obligation it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract, or 3. When demand would be useless, as when the obliger has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, delay by the other begins. Delay has nothing to do with quality but only with punctuality. Delay is the non-fulfillment of the obligation with respect to time. In fraud and negligence, the question is the quality even if performed on time. In delay, even if the quality is excellent but the performance is not in due time, the debtor is liable. Requisites of delay, SSS vs Moonwalk. Obligation is demandable and liquidated. Delay is through fault or negligence. Creditor requires performance either judicially, through court action, or extrajudicially, any communication by the creditor to debtor. In reciprocal obligations, obligations with a counterpart prestation, which require simultaneous performance, demand is still needed. What is the form of such demand? Any communication of a party that he is ready and willing to comply with his obligation. If after receipt of demand and the other party does not comply with his obligation, he is in delay. 3 kinds of delay. 1. Mora solvendi. Delay in performance incurred by the debtor. Requisites. The obligation is demandable and liquidated. B. Debtor delays performance either because of dolo or culpa. C. The creditor demands the performance either judicially or extrajudicially. General rule: demand is necessary. Mora solvendi ex persona. Thus, no demand, no delay. Exceptions: mora solvendi ex re, Article 1169a. When the obligation or the law expressly so declares. Mere setting of due date is not enough. This does not constitute automatic delay. There must be an express stipulation to the following effect: non-performance on that day is delay without need of demand. Della Rosa vs BPI. B. When it appears from the nature and circumstances of the obligation that time was a controlling motive for the establishment of the contract. Example: the wedding gown has to be ready before the wedding. C. When demand would be useless, when obliger has rendered it beyond his power to perform. Example: A sold the fruits of the mango plantation he already sold to B to C. B need not make a demand on A to deliver the fruits since demand would be useless. Effects of mora salvidi. When the obligation is to deliver a determinate thing, the risk is placed on the part of the debtor, Article 1165, B. Damages. See rescission/resolution, Article 1191, 2. Mora accipiendi. The creditor incurs in delay when debtor tenders payment or performance, but the creditor refuses to accept it without just cause. Mora accipiendi is related to payment. Consignation. Art. 1165. When what is to be delivered is a determinate thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obliger delays, or has promised to deliver the same thing to 2 or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. Requisites. An offer of performance by the debtor who has the required capacity. B. The offer must be to comply with the prestation as it should be performed. C. The creditor refuses the performance without just cause. Effects of mora accipiendi. A responsibility of debtor for the thing is limited to fraud and gross negligence. B. Debtor is exempted from risk of loss of thing with C. automatically passed to creditor. C. Expenses incurred by debtor for preservation of thing after the delay shall be chargeable to creditor. D. If the obligation has interest, debtor shall not have obligation to pay the same from the time of the delay. E. Creditor becomes liable for damages. F. Debtor may relieve himself by consignation of the thing. 3. Compensatio Mauri. Delay on both sides in reciprocal obligations, cancel each other out. B. Not attributable to the debtor, non-culpable, fortuitous event. Art. 1174 except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. Also governed by Article 1221 but is called loss there, a cause for extinguishment of obligation. Also called caso fortuito, force majeure, act of God. Requisites, NACPL vs. 1. The cause of the unforeseen and unexpected occurrence, or the failure to comply with his obligations, must be independent of the human will. Art. 1221 If the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. If there was fault on the part of any one of them, all shall be responsible to the creditor, for the price and the payment of damages and interest, without prejudice to their action against the guilty or negligent debtor. If through a fortuitous event, the thing is lost or the performance has become impossible after one of the solidary debtors has incurred in delay through the judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraph shall apply. 2. It must be impossible to foresee the event which constitute the caso fortuito, or if it can be foreseen, it must be impossible to avoid. 3. The occurrence must be such as to render it impossible for the debtor to fulfill his obligation in a normal manner. 4. The obliger must be free from any participation in the aggravation of the injury resulting to the creditor. General rule: when a debtor is unable to fulfill his obligation because of a fortuitous event or force majeure, he cannot be held liable for damages or non-performance. Exceptions. 1. When the law so provides, i.e. Article 1165, 2. When there is express stipulation. Fortuitous event yields to contrary stipulation. 3. When the nature of the obligation requires the assumption of risk, i.e. insurance contracts. 3. Other provisions. Art. 1175 Usurious transactions shall be governed by special laws. Article 1175 is dead-letter law because of the lifting of the ceiling on interest rates. Thus, usury has been decriminalized, but the decriminalization cannot be given retroactive effect, with respect to the civil aspect. Some decisions have struck down high interests, not because they were usurious but because such rates were unconscionable. Correlate Article 1175 with Articles 1957, 1413 and 1961. Art. 1176 The receipt of the principal by the creditor without reservation with respect to the interest, shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservation as to prior installments, shall likewise raise the presumption that such installments have been paid. 2. Presumptions regarding a interest-bearing debt. Article 1165, 2. If the obliger delays, or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. Art. 1957 Contracts and stipulations, under any cloak or device whatever, intended to circumvent the laws against usury shall be void. The borrower may recover in accordance with the laws on usury. Art. 1413 Interest paid in excess of the interest allowed by the usury laws may be recovered by the debtor, with interest thereon from the date of the payment. Art. 1961 Usurious contracts shall be governed by the usury law and other special laws, so far as they are not inconsistent with this code. Presumption that interest has been paid if the principal has been received without reservation regarding interest, be debt payable in installments. Presumption that earlier installments have been paid if the later installment has been received without reservation regarding the previous installments. These are only rebuttable presumptions, you can prove through other evidence. You can prove mistake. Art. 1177 The creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. Enforcement of creditors' remedies. A levy and execution of the debtor's non-exempt properties, Articles 1177, 2236, Be Action Subrogatoria. Subrogatory action premised on the theory that, the debtor of my debtor is my debtor. Requisites. A creditor has a right of credit against the debtor. 2. Credit is due and demandable. 3. Failure of debtor to collect his own credit from a third person either through malice or negligence. 4. Insufficiency of assets of the debtor to satisfy the creditor's credit. V. Right of account is not intuito personi si acción pauliana, Articles 1380 to 1389. Right of creditors to rescind alienations by debtor which are prejudicial to them to the extent of the prejudice. Example: A donates land to C but he owes B. A has no other property. B can rescind the donation to C. The donation is rescissible to the extent of the debt. Requisites. I. There is a credit in favor of the plaintiff. 2. The debtor has performed an act subsequent to the contract, giving advantage to other persons. 3. The creditor is prejudiced by the debtor's act which are in favor of third parties and rescission will benefit the creditor. 4. The creditor has no other legal remedy. V. The debtor's acts are fraudulent. Art. 2236 The debtor is liable with all his property, present and future, for the fulfillment of his obligations, subject to the exemptions provided by law. De acción directa. A direct, not subrogatory, action by the creditor against his debtor's debtor, a remedy which gives the creditor the prerogative to act in his own name, such as the actions of the lessor against the sublessee, Article 1652. The laborer of an independent contractor against the owner, Article 1729, the principal against the subagent, Article 1893, and the vendor arbitro against the transferee of the vendee, Article 1608. This is an exception to the relativity of contracts. Example 1. There are two separate contracts here, the contract of lease between A and B and the contract of sublease between B and C. C owes B P7,000. B owes A P5,000. Ordinarily, A cannot sue C since there is no relationship between them, but in Article 1652, A can sue C for P5,000. Example 2. Again, there are two separate contracts here, the contract for a piece of work between A and B and the contract of labor between B and C. A owes B P10,000 which is not fully paid yet. B owes C P5,000 for unpaid wages. C can go after A directly for P5,000. Art. 1652 The sublessee is subsidiarily liable to the lessor for any rent due from the lessee. However, the sublessee shall not be responsible beyond the amount of rent due from him, in accordance with the terms of the sublease, at the time of the extrajudicial demand by the lessor. Payments of rent in advance by the sublessee shall be deemed not to have been made, so far as the lessor's claim is concerned, unless said payments were effected in virtue of the custom of the place. Art. 1729 Those who put their labor upon or furnish materials for a piece of work undertaken by the contractor have an action against the owner up to the amount owing from the latter to the contractor at the time the claim is made. However, the following shall not prejudice the laborers, employees, and furnishers of materials. 1. Payments made by the owner to the contractor before they are due. 2. Renunciation by the contractor of any amount due him from the owner. This article is subject to the provisions of special laws. Art. 1893. In the cases mentioned in NOS 1 and 2 of the preceding article, the principal may furthermore bring an action against the substitute with respect to the obligations which the latter has contracted under the substitution. Art. 1608 The vendor may bring his action against every possessor whose right is derived from the vendee, even if in the second contract no mention should have been made of the right to repurchase, without prejudice to the provisions of the mortgage law and the land registration law with respect to third persons. Sublease leasia. B. C. Piece of work. A. Customer. Labor. CB. Contract off contract for a contractor. Worker. Art. 1178 Subject to the laws, all rights acquired in virtue of an obligation are transmissible, if there has been no stipulation to the contrary. Rights are transmissible unless the rights are personal. G. Different kinds of obligations. 1. According to demandability, Articles 1179 to 1192. Art. 1179 Every obligation whose performance does not depend upon a future or uncertain event, or upon a past event unknown to the parties, is demandable at once. Every obligation which contains a resolutory condition shall also be demandable, without prejudice to the effects of the happening of the event. Art. 1180 When the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of Article 1197. Art. 1181 In conditional obligations, the acquisition of rights, as well as the extinguishment or loss of those already acquired, shall depend upon the happening of the event which constitutes the condition. Art. 1182 When the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of this code. Art. 1183 Impossible conditions, those contrary to good customs or public policy and those prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, that part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. Art. 1184 The condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires or if it has become indubitable that the event will not take place. Art. 1185 The condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. Art. 1186 The condition shall be deemed fulfilled when the obliger voluntarily prevents its fulfillment. Art. 1187 The effects of a conditional obligation to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Nevertheless, when the obligation imposes reciprocal prestations upon the parties, the fruits and interests during the pendency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interests received, unless from the nature and circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. In obligations to do and not to do, the courts shall determine, in each case, the retroactive effect of the condition that has been complied with. Art. 1188 The creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. Art. 1189 When the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. 1. If the thing is lost without the fault of the debtor, the obligation shall be extinguished. 2. If the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. 3. When the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. 4. If it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment, with indemnity for damages in either case. 5. If the thing is improved by its nature, or by time, the improvement shall inure to the benefit of the creditor. 6. If it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. Art. 1190. When the conditions have for their purpose the extinguishment of an obligation to give, the parties, upon the fulfillment of said conditions, shall return to each other what they have received. In case of the loss, deterioration, or improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. As for the obligations to do and not to do, the provisions of the second paragraph of Article 1187 shall be observed as regards the effect of the extinguishment of the obligation. Art. 1191. The power to rescind obligations is implied in reciprocal ones, in case one of the obligers should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation, with the payment of damages in either case. He may also seek rescission, even after he has chosen fulfillment, if the latter should become impossible. The court shall decree the rescission claimed, unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third persons who have acquired the thing, in accordance with Articles 1385 and 1388 and the Mortgage Law. Art. 1192. In case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and each shall bear his own damages. A pure obligation is one which has neither a condition nor a term attached to it. It is one which is subject to no contingency. A pure obligation is demandable at once. Article 1179. Be conditional. A condition is a future and uncertain event. All conditions are future. Article 1179 mentions the term past event unknown to the parties. This has been criticized by many commentators. This is a contradiction in terms. The condition in a past even unknown to the parties is knowledge by the parties of the past event. In conditional obligation, the happening of the condition determines its birth or death. In term, the happening of the term determines its demandability. Types of conditions. I1. Suspensive. The fulfillment of a suspensive condition results in the acquisition of rights arising out of the obligation. The condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. Article 1184. The condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. Article 1185. The moment the suspensive condition happens, the obligation becomes effective and enforceable. However, the effects of the obligation retroact to the moment when such obligation was constituted or created. By the principle of retroactivity, therefore, a fiction is created whereby the binding tie of the conditional obligation is produced from the time of its perfection, and not from the happening of the condition. Article 1187. The law does not require the delivery or payment of the fruits or interests accruing before the happening of the suspensive condition. The right to the fruits of the thing is not within the principle of retroactivity of conditional obligations. Article 1187. If the obligation imposes reciprocal prestations, fruits and interest are deemed mutually compensated. Example: I promise to sell my mango plantation at P5000/hectare if you pass the bar examination. I do not have to give you the fruits from the time of the agreement to the release of the bar exams. If the obligation is unilateral, debtor appropriates the fruits. In obligations to do and not to do, the courts shall use sound discretion to determine the retroactive effect of the fulfillment of the condition. Article 1187. The creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. Article 1188, first. JBL Reyes criticizes the use of the word bring. The first of Article 1188 does not limit itself to judicial actions. Thus, the word take is better. The debtor who paid before the happening of the condition may recover only when he paid by mistake and provided the action to recover is brought before the condition. Article 1188. 2. Resolutory. The fulfillment of the resolutory condition results in the extinguishments of rights arising out of the obligation. If the resolutory condition is fulfilled, the obligation is treated as if it did not exist. Thus, each party is bound to return to the other whatever he has received, so that they may be returned to their original condition before the creation of the obligation. Article 1190. Resolution, Article 1191, is found on the conditional obligations because if there is a breach, the breach is a resolutory condition which extinguishes the obligation. Article 1191 uses the term rescission. The better term is resolution. The term rescission is also found in Article 1381, Rescissible Contracts. Resolution is different from rescission. Resolution is based on the non-fulfillment of the obligation. Rescission is based on economic prejudice. Furthermore, the character of resolution is principal and retaliatory while the character of rescission is subsidiary. This means that in resolution there is no need to show that there is no other remedy. In rescission, the plaintiff must show that there is no other recourse. The right of resolution applies to reciprocal obligations. A reciprocal obligation has two elements: 1. Two prestations arising from the same source. 2. Each prestation is designed to be the counterpart of the other. An example of a reciprocal obligation is a contract of sale. Summary of rulings on resolution. 1. The right to resolve is inherent in reciprocal obligations. 2. The breach of the obligation must be substantial. Proof of substantial breach is a prerequisite for resolution. 3. The right of resolution can be exercised extrajudicially and will take effect upon communication to the defaulting party. This notice of resolution is necessary. 4. The exercise of this right can be the subject of judicial review. 5. Upon resolution, there must be mutual restitution of the object and its fruits. The parties are returned to their original situation, status quo ante. 6. If the aggrieved party has not performed the prestation and resolves extrajudicially, then all the aggrieved party has to do is to refuse to perform his prestation. 7. If the aggrieved party has performed the prestation, the aggrieved party can demand recovery. If the defaulting party refuses to return it, the aggrieved party must go to court in order to recover. In Illingan vs.ca, September 26, 2001, case, there was an obiter dictum that the operative act that resolves a contract is the decree of court and the right should be exercised judicially. Professor Balain says this is wrong. However, the ratio of the case said that the communication must be a notarial notice. 2.1. Potestative. In a potestative condition, the fulfillment of the condition depends upon the will of a party to the obligation. If the condition depends upon the will of the creditor, then the obligation is valid. In this case, there is a vinculum juris. The creditor can compel the debtor to perform the obligation. Example: I will give you my pomelo plantation if you establish permanent residence in Davo. This is a suspensive condition dependent on the sole will of the creditor. It becomes pure and demandable at once. Article 1182 prohibits a suspensive potestative condition dependent on the will of the debtor. The entire obligation is void. Example: I will sell you my car if I want to. Why does it annul the entire obligation? Because there is no juridical tie. Remember, an obligation is one which has to be performed regardless of the will of the debtor. There is no element of compulsion. In the example above, the creditor can never compel, can never have a cause of action. In reciprocal obligations, the law only talks about the first prestation, the reciprocal prestation is not taken into consideration. 2. Casual. In a casual condition, the fulfillment of the condition depends upon chance and/or upon the will of a third person and not on the will of a party. Example, I will give you my house if the Philippines renounces its foreign debt in 5 years. Dependent solely on the will of a third person or on chance. 3. Mixed. In a mixed condition, the fulfillment of the condition depends partly upon the will of a party to the obligation and partly upon chance and/or the will of a third person. When the condition depends not only upon the will of the debtor, but also upon chance or will of the others, the obligation is valid. Example, I will give you my house if you marry him within 3 years. The condition here is a mixed condition. In this case, the condition of marriage depends partly on the creditor, a party to the obligation, and partly on a third person. Doctrine of constructive compliance. The condition shall be deemed fulfilled when the obliger voluntarily prevents its fulfillment. Article 1186. The principle underlying constructive fulfillment of conditions is that a party to a contract may not be excused from performing his promise by the non-occurrence of an event which he himself prevented. Requisites. 1. Intent of the debtor to prevent fulfillment of the obligation. Where the act of the debtor, however, although voluntary, did not have for its purpose the prevention of the fulfillment of the condition, it will not fall under the doctrine of constructive compliance. 2. Actual prevention of compliance. The doctrine of constructive compliance applies to potestative and mixed conditions. 3.1. Possible. A condition is possible when it is capable of realization according to nature, law, public policy, or good customs. 2. Impossible. A condition is impossible when it is not capable of realization according to nature, law, public policy, or good customs. The effect of an impossible condition is to annul the obligation. Article 1183. The effect of an impossible condition regarding donations and succession is different. In donations and succession, an impossible condition is simply disregarded. The distinction can be explained by the fact that Article 1183 refers to onerous obligation whereas donations and succession are gratuitous. However, if the obligation is divisible and that part of the obligation is not unaffected by the impossible condition, then the obligation is valid. Article 1183. Justice Paras distinguishes as follows. 1. Positive condition to do something impossible. Void condition and obligation. 2. Negative condition not to do something impossible. Disregard the condition, the obligation is valid. 3. Negative condition not to do something illegal. Valid condition and obligation. 4. 1. Positive. A condition is positive when the condition involves the performance of an act. 2. Negative. A condition is negative when the condition involves the non-performance of an act. V1. Divisible. A condition is divisible when the condition is susceptible of partial realization. 2. Indivisible. A condition is indivisible when the condition is not susceptible of partial realization. 6. 1. Conjunctive. A condition is conjunctive when there are several conditions, all of which must be realized. 2. Alternative. A condition is alternative when there are several conditions, only one of which must be realized. 7.1. Express. A condition is express when the condition is stated expressly. 2. Implied. A condition is implied when the condition is tacit. See term, Articles 1193 to 1198. Art. 1193 Obligations for whose fulfillment a day certain has been fixed, shall be demandable only when that day comes. Obligations with a resolutory period take effect at once, but terminate upon arrival of the day certain. A day certain is understood to be that which must necessarily come, although it may not be known when. If the uncertainty consists in whether the day will come or not, the obligation is conditional, and it shall be regulated by the rules of the preceding section. Art. 1194. In case of loss, deterioration, or improvement of the thing before the arrival of the day certain, the rules in Article 1189 shall be observed. Art. 1195. Anything paid or delivered before the arrival of the period, the obliger being unaware of the period or believing that the obligation has become due and demandable, may be recovered, with the fruits and interests. Art. 1196. Whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor, unless from the tenor of the same or other circumstances it should appear that the period has been established in favor of one or of the other. Art. 1197. If the obligation does not fix a period, but from its nature and the circumstances it can be inferred that a period was intended, the courts may fix the duration thereof. The courts shall also fix the duration of the period when it depends upon the will of the debtor. In every case, the courts shall determine such period as may under the circumstances have been probably contemplated by the parties. Once fixed by the courts, the period cannot be changed by them. Art. 1198. The debtor shall lose every right to make use of the period. 1. When after the obligation has been contracted, he becomes insolvent, unless he gives a guarantee or security for the debt. 2. When he does not furnish to the creditor the guarantees or securities which he has promised. 3. When by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. 4. When the debtor violates any undertaking, in consideration of which the creditor agreed to the period. 5. When the debtor attempts to abscond. A term is a length of time which, exerting an influence on an obligation as a consequence of juridical acts, suspends its demandability or determines its extinguishment. A term is a future and certain event, i.e. death. When the debtor binds himself to pay when his means permit him to do so, the obligation is one with a term, Article 1180. Although Article 1180 looks like a condition dependent on the sole will of the debtor, the law treats it as a term. If prepayment is made without the debtor being aware that the period had not yet arrived, then the thing and the fruits can be recovered, Article 1195. If prepayment is made and the debtor was aware that the period had not yet arrived, then the debtor waives the benefit of the term. An obligation was entered on May 1, 2002 between A and B. The obligation is to be performed on October 1, 2002. A delivers on September 1, 2002 by mistake to B. A discovers his mistake and tells B to return the object and the fruits delivered. Article 1195 does not answer who is entitled to the fruits which have been produced in the meantime, May 1, 2002 to October 1, 2002. According to the Spanish Code, the debtor, A, can only fruits. There are two views. I. The debtor is entitled to the fruits produced in the meantime. Tolentino. This is because delivery is not required until October 1. 2. The creditor is entitled to the fruits since the obligation is demandable only when the period arrives. This is because the obligation is already existing although it is not yet demandable. Professor Balain believes that the fruits belong to the debtor. Why would Article 1195 allow the debtor to recover the fruits if he should still give them back after the term comes? Instances when the fruits cannot be recovered. I. When the obligation is reciprocal and there has been prepayment of both sides. 2. When the obligation is a loan and the debtor is bound to pay interest. 3. When the period is exclusively for the creditor's benefit. 4. When the debtor is aware of the period and pays anyway, waiver. The presumption is that the period is for the benefit of both the debtor and the creditor, Article 1196. The effect of this presumption is that the creditor cannot demand payment before the period arrives, nor can the debtor demand the creditor to accept payment before the period arrives. Example: A issues a promissory note to be demandable on October 15. A cannot insist on prepayment, nor can B insist that he be paid on September. If the period is for the benefit of the creditor only, the creditor can demand performance at any time, but the debtor cannot compel him to accept payment before the period expires. If the period is for the benefit of the debtor only, the debtor may oppose a premature demand for payment, but may validly pay at any time before the period expires. When the obligation is worded such that payment is to be made within 6 months, the period is for the benefit of the debtor. When the obligation is worded such that payment is to be made on or before, the period is for the benefit of the debtor. The debtor shall lose every right to make use of the period, when after the obligation has been contracted, the debtor becomes insolvent unless he gives a guarantee or security for the debt. Article 1198, 1. The insolvency here need not be judicial. It can be actual insolvency. 2. When he does not furnish to the creditor the guarantees or securities which he has promised. Article 1198, 2. 3. When by his own acts he has impaired the said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. Article 1198, 3. 4. When the debtor violates any undertaking, in consideration of which the creditor agreed. Article 1198, 4. v. When the debtor attempts to abscond. Article 1198, 5, 6. When the creditor is deceived on the substance or quality of the thing pledged, the creditor may either claim another thing in its stead or demand immediate payment of the principal obligation. Article 2109. Types of periods. I-1. Suspensive, ex-die. The period is suspensive when the obligation becomes demandable only upon the arrival of the period. 2. Resolutory, in diem. The period is resolutory when the performance must terminate upon the arrival of the period. 2.1. Legal. A period is legal when it is granted by law. 2. Voluntary. A period is voluntary when it is stipulated by the parties. 3. Judicial. A period is judicial when it is fixed by the courts. If the obligation does not fix a period, but from its nature and the circumstances it can be inferred that a period was intended, the courts may fix the duration thereof. Article 1197, first. 2 steps involved in an action for fixing a period. 1. The court should determine that the obligation does not fix a period, but it can be inferred that a period is intended due to the circumstances or the period is dependent on debtor's will. 2. Court shall decide what period was probably contemplated by the parties. Court should make an educated guess. Court should not fix a period which it thinks is fair or reasonable, but rather the period which was probably contemplated by the parties. Generally, you cannot ask for specific performance because fixing a period contemplates something in the future, hence to ask for specific performance would be illogical. Instances when court may fix a period. 1. Article 1197, 1. Art. 1197, 1. If the obligation does not fix a period, but from its nature and the circumstances it can be inferred that a period was intended, the courts may fix the duration thereof. Exceptions. A. Articles 1682 and 1687, first sentence. Art. 1682. The lease of a piece of rural land, when its duration has not been fixed, is understood to have been for all the time necessary for the gathering of the fruits which the whole estate leased may yield in 1 year, or which it may yield once, although 2 or more years have to elapse for the purpose. Art. 1687, first sentence. If the period for the lease has not been fixed, it is understood to be from year to year, if the rent agreed upon is annual, from month to month, if it is monthly, from week to week, if the rent is weekly, and from day to day, if the rent is to be paid daily. B. Pacto de retro sales, Article 1606. Art. 1606. The right referred to in Article 1601, in the absence of an express agreement, shall last 4 years from the date of the contract. Should there be an agreement, the period cannot exceed 10 years. However, the vendor may still exercise the right to repurchase within 30 days from the time final judgment was rendered in a civil action on the basis that the contract was a true sale with right to repurchase. C. Contract of services for an indefinite period. Court cannot fix a period or else it would amount to involuntary servitude. 2 Article 1197, 2. Art. 1197, 2. The courts shall also fix the duration of the period when it depends upon the will of the debtor. 3 Article 1191, 3. Art. 1191, 3. The court shall decree the rescission claimed, unless there be just cause authorizing the fixing of a period. 4 Article 1687, 2nd, 3rd and 4th sentences. Art. 1687, 2nd, 3rd and 4th sentences. However, even though a monthly rent is paid, and no period for the lease has been set, the courts may fix a longer term for the lease after the lessee has occupied the premises for over 1 year. If the rent is weekly, the courts may likewise determine a longer period after the lessee has been in possession for over 6 months. In case of daily rent, the courts may also fix a longer period after the lessee has stayed in the place for over 1 month. 5 Article 1180. Art. 1180. When the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of Article 1197. 3.1. Express. A period is express when the period is specifically stated. 2. Tacit. A period is tacit when a person undertakes to do some work which can be done only during a particular season. 4.1. Original. 2. Grace. A grace period is an extension fixed by the parties or by the court. V1. Definite. A period is definite when it refers to a fixed known date or time. 2. Indefinite. A period is indefinite when it refers to an event which will necessarily happen but the date of its happening is unknown, i.e. death. 2. According to plurality of object, Articles 1199 to 1206. Art. 1199. A person alternatively bound by different prestations shall completely perform one of them. The creditor cannot be compelled to receive part of one and part of the other undertaking. Art. 1200. The right of choice belongs to the debtor, unless it has been expressly granted to the creditor. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. Art. 1201. The choice shall produce no effect except from the time it has been communicated. Art. 1202. The debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable. Art. 1203. If through the creditor's acts the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract with damages. Art. 1204. The creditor shall have a right to indemnity for damages when, through the fault of the debtor, all the things which are alternatively the object of the obligation have been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed taking as a basis the value of the last thing which disappeared, or that of the service which last became impossible. Damages other than the value of the last thing or service may also be awarded. Art. 1205. When the choice has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Until then the responsibility of the debtor shall be governed by the following rules. 1. If one of the things is lost through a fortuitous event, he shall perform the obligation by delivering that which the creditor should choose from among the remainder, or that which remains if only one subsists. 2. If the loss of one of the things occurs through the fault of the debtor, the creditor may claim any of those subsisting, or the price of that which, through the fault of the former, has disappeared, with the right to damages. 3. If all the things are lost through the fault of the debtor, the choice by the creditor shall fall upon the price of any one of them, also with indemnity for damages. The same rules shall be applied to obligations to do or not to do in case one, some or all of the prestations should become impossible. Art. 1206. When only one prestation has been agreed upon, but the obliger may render another in substitution, the obligation is called facultative. The loss or deterioration of the thing intended as a substitute, through the negligence of the obliger, does not render him liable. But once the substitution has been made, the obliger is liable for the loss of the substitute on account of his delay, negligence, or fraud. A. Alternative. An obligation is alternative when several objects or prestations are due, but the payment or performance of one of them would be sufficient. A promise is to deliver either 500 kgs of rice or 1,000 liters of gas. The obligation is alternative. The debtor cannot perform the obligation by giving 250 kgs of rice and 500 liters of gas unless the creditor agrees, in which case there is a novation. General rule: the right of choice, the right to, belongs to the debtor. Exceptions: I. When it is expressly granted to the creditor. 2. When it is agreed upon by the parties that a third person shall make the choice. The act of making the choice is called concentration. Once the choice has been made, then the obligation is concentrated in one object. Whoever has the right of choice must communicate it to the other party, Article 1201. The creditor has to communicate his choice to the debtor so that the debtor will know. On the other hand, in Ongguan vs. Century Insurance, the Supreme Court said that the purpose for notice to the creditor is to give the creditor the opportunity to express his consent or to impugn the election made by the debtor. Professor Balain does not agree with this statement since the creditor does not have the right to impugn, otherwise, the obligation would not be an alternative obligation. A better reason according to Professor Balain is to give the creditor time to prepare. Example: the choice is either to give diamond ring or a Mercedes-Benz. The debtor should notify the creditor so the creditor can either rent a safety deposit box or prepare a garage. However, according to Professor Balain, the best reason is because once the choice is communicated, the obligation ceases to be alternative. The risk of loss belongs to the creditor now. Choice belongs to the debtor. I. When through fortuitous event or through the debtor's acts, there is only one prestation left, the obligation ceases to be alternative, Article 1202. 2. When the choice of the debtor is limited through the creditor's own acts, then the debtor has the remedy of resolution, Article 1191, plus damages, Article 1203. 3. When all the things are lost due to the debtor's fault, the creditor can sue for damages, Article 1204. 4. When some things are lost due to the debtor's fault but there are still some things remaining, then the debtor can choose from what's left. V. When all the things are lost due to a fortuitous event, the obligation is extinguished. 6. When all but one of the things are lost due to a fortuitous event and the last object is lost through the debtor's fault, then the creditor can sue for damages. 7. When all but one of the things are lost through the debtor's own acts and the last object is lost through a fortuitous event, the obligation is extinguished. Choice belongs to the creditor, Article 1205. I. When one or some of the objects are lost through fortuitous events, then the creditor chooses from the remainder. 2. When one or some of the objects are lost due to the debtor's fault, the creditor may choose from the remainder or get the value of any of the objects lost plus damages in either case. 3. When all of the things are lost due to the debtor's fault, the creditor can get the value of any of the objects lost plus damages. 4. When some are lost through the debtor's fault, the creditor chooses from the remainder. V. When all the objects are lost due to a fortuitous event, then the obligation is extinguished. 6. When all the objects are lost due to the creditor's fault, the obligation is extinguished. Be facultative. An obligation is facultative when only one object or prestation has been agreed upon by the parties to the obligation, but the debtor may deliver or render another in substitution. Facultative obligations bear a resemblance to alternative obligations, particularly when the choice in an alternative obligation is with the debtor. In a facultative obligation, the right of choice is always with the debtor. In an alternative obligation, if one of the prestations is impossible, then there are other choices. In a facultative obligation, if the principal obligation is impossible, then everything is annulled. In theory, it is easy to distinguish a facultative obligation from an alternative obligation. In practice, it is difficult to do so since most of the time, the words are ambiguous. For example, I promise to deliver my Honda Accord, but I reserve my right to substitute this with my gold Rolex. In this case, it is not very clear whether the obligation is alternative or facultative. According to Professor Balain, the rule is that one must look at the circumstances of the obligation. If it is impossible to determine which one, then the doubt should be resolved in the favor of an alternative obligation since its effects are less radical. 3. According to plurality of subject, Articles 1207 to 1222. Art. 1207. The concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand, or that each one of the latter is bound to render entire compliance with the prestation. There is a solidary liability only when the obligation expressly so states, or when the law or the nature of the obligation requires solidarity. Art. 1208. If from the law, or the nature or the wording of the obligations to which the preceding article refers the contrary does not appear, the credit or debt shall be presumed to be divided into as many shares as there are creditors or debtors. The credits or debts being considered distinct from one another, subject to the rules of court governing the multiplicity of suits. Art. 1209. If the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the others shall not be liable for his share. Art. 1210. The indivisibility of an obligation does not necessarily give rise to solidarity. Nor does solidarity of itself imply indivisibility. Art. 1211. Solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. Art. 1212. Each one of the solidary creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. Art. 1213. A solidary creditor cannot assign his rights without the consent of the others. Art. 1214. The debtor may pay any one of the solidary creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. Art. 1215. Novation, compensation, confusion, or remission of the debt, made by any of the solidary creditors or with any of the solidary debtors, shall extinguish the obligation, without prejudice to the provisions of Article 1219. The creditor who may have executed any of these acts, as well as he who collects the debt, shall be liable to the others for the share in the obligation corresponding to them. Art. 1216. The creditor may proceed against any one of the solidary debtors or some or all of them simultaneously. The demand made against one of them shall not be an obstacle to those which may subsequently be directed against the others, so long as the debt has not been fully collected. Art. 1217. Payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offer to pay, the creditor may choose which offer to accept. He who made the payment may claim from his co-debtors only the share which corresponds to each, with the interest for the payment already made. If the payment is made before the debt is due, no interest for the intervening period may be demanded. When one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors, in proportion to the debt of each. Art. 1218. Payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. Art. 1219. The remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors, in case the debt had been totally paid by any one of them before the remission was effected. Art. 1220. The remission of the whole obligation, obtained by one of the solidary debtors, does not entitle him to reimbursement from his co-debtors. Art. 1221. If the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. If there was fault on the part of any one of them, all shall be responsible to the creditor, for the price and the payment of damages and interest, without prejudice to their action against the guilty or negligent debtor. If through a fortuitous event, the thing is lost or the performance has become impossible after one of the solidary debtors has incurred in delay through the judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraph shall apply. Art. 1222. A solidary debtor may, in actions filed by the creditor, avail himself of all defenses which are derived from the nature of the obligation and of those which are personal to him, or pertain to his own share. With respect to those which personally belong to the others, he may avail himself thereof only as regards that part of the debt for which the latter are responsible. A single. An obligation is single when there is only one debtor and one creditor. Be joint. An obligation is joint when each of the debtor is liable only for a proportional part of the debt, and each creditor is entitled only to a partial part of the credit. A joint obligation is also called mancommunita, pro rata, mancommunita simple. General rule: the obligation is joint since joint obligations are less onerous. Exceptions: I. Agreement of the parties. 2. Law, i.e. tortfeasors are solidarily liable. 3. Nature of the obligation. According to many commentators, this is superfluous since a solidary obligation arises because of law. Essential nature: there are as many obligations as there are creditors multiplied by as many debtors. Types of joint obligations. I. Active joint. In active joint, there are multiple creditors. A, B, and C are creditors, and X is the debtor. If the obligation is joint, there are three obligations: X's obligation to A, X's obligation to B, and X's obligation to C. The demand of one creditor on one debtor will not constitute a demand on the others. The prescription of one of the debts will not affect the other debts. 2. Passive joint. In passive joint, there are multiple debtors. X, Y, and Z are debtor, and A is the creditor. If the obligation is joint, there are three obligations: X's obligation to A, Y's obligation to A, and Z's obligation to A. The demand of one creditor on one debtor will not constitute a demand on the others. The prescription of one of the debts will not affect the other debts. The insolvency of one of the debtors will not affect the burden of the other debtors. 3. Mixed joint. In mixed joint, there are multiple creditors and debtors. X, Y, and Z are debtors, and A, B, and C are the creditors. If the obligation is joint, there are 9 obligations: X's obligation to A, X's obligation to B, X's obligation to C, Y's obligation A, Y's obligation to B, Y's obligation to C, Z's obligation to A, Z's obligation to B, and Z's obligation to C. See solidary. An obligation is solidary when any of the debtors can be HLED liable for the entire obligation, and any of the creditors is entitled to demand the entire obligation. A solidary obligation is also called joint and several, joint and individual, and insolidum. If a promissory says, "I promise to pay," and it is signed by K, B, and M, then the obligation is solidary. An obligation is solidary when the parties so agree. 2. When the law so provides, i.e. tortfeasors are solidarily liable. 3. When nature of the obligation requires the obligation to be solidary. According to many commentators, this is superfluous since a solidary obligation arises because of law. Types of solidary obligations. I. Active solidary. In active solidary, there are multiple creditors. Characteristics of active solidary. A credit once paid is shared equally among the creditors unless a different intention appears. The debtor may pay any of the creditors, but if any demand, judicial or extrajudicial, is made on him, he must pay only to the one demanding payment. Article 1214. Article 1214 can be open to abuse. For example, if A writes Y demanding the performance of the obligation and A takes no further action, B and C cannot demand from Y. This is open to collusion. Suppose A, B, and C are creditors of X. A demands the payment of the loan worth P9,000. X instead pays to B. The payment to B will be treated as a payment to a third person. Therefore, X must still pay the amount of the loan minus the share of B. So, X has to pay P6,000 to A. 2. Passive solidary. In passive solidary, there are multiple debtors. Characteristics of passive solidary. Each debtor may be required to pay the entire obligation, but after payment, he can recover from his co-debtors their respective shares. 3. Mixed solidary. In mixed solidary, there are multiple debtors and creditors. Characteristics of mixed solidary. A credit once paid is shared equally among the creditors unless a different intention appears. The debtor may pay any of the creditors, but if any demand, judicial or extrajudicial, is made on him, he must pay only to the one demanding payment. Article 1214. According to Professor Balain, Article 1214 is problematic. For example, X owes A, B and C. B makes an extrajudicial demand on X. X cannot pay or C anymore. The problem is when B does not follow up the demand, it can keep the obligation in suspension indefinitely. The rule in the Spanish Code was that the debtor cannot pay the other non-demanding solidary creditors only if one of the solidary creditor makes a judicial demand. Suppose the debtor upon whom the demand is made pays a creditor who did not make a demand. The payment is considered a payment to a third person. Therefore the debtor can still be made to pay by the one who made the demand on him. Example, X owes A and B. B demanded from X. X pays A. X must still pay B P6,000. But the payment to the demanding creditor can be reduced by the share of the paid creditor. The debtor can still recover from the paid creditor. Unjust enrichment. Suppose A and B are creditors while X and Y are debtors. A demands from Y. Now, X pays B. The payment of X to B extinguishes the entire solidary obligation. X is not bound by the demand by A on Y. There is no violation of Article 1214. Each debtor may be required to pay the entire obligation, but after payment, he can recover from his co-debtors their respective shares. Is there a conflict between Article 1212 and Article 1215? Article 1212 provides that each of the solidary creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. But Article 1215 allows novation, compensation, confusion, or remission on the part of the solidary creditor. Why? According to Professor Balain, this is absurd. One way of reconciling is that under Article 1215, any creditor can remit or condone the obligation. But because the obligation is extinguished, the condoning creditor must be liable for the other creditor's share. Here, there is no prejudice. However, another problem arises if the condoning creditor later on becomes insolvent. Art. 1219. The remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors, in case the debt had been totally paid by any one of them before the remission was effected. A is the creditor of W, X, Y, and Z. W, X, Y, and Z owe a P6,000. The obligation is solidary. A remits Y's share, P1,500. A can go after X for only P4,500. The remission benefits X initially since X only has to pay P4,500 instead of 6,000. However, X can only recover P3,000 from W and Z. A is the creditor of W, X, Y, and Z. W, X, Y, and ZOAP 6,000. The obligation is solidary. A remits-wise share, P1,500. A can go after Y for the balance since Y is still a solidary debtor for the balance. Otherwise, the effect of remission would be extended. However, Y can recover P4,500 from W, X, and Z. A is the creditor of W, X, Y, and Z. W, X, Y, and ZOAP 6,000. The obligation is solidary. A remits-wise share, P1,500. Z becomes insolvent. A sues W for the balance of P4,500. Art. 1217 must be applied. Thus, the insolvency of Z is shouldered by W, X, and Y. So, W can recover P2,000 from X and P500 from Y instead of collecting P3,000. W has to shoulder P500 as a loss due to Z's insolvency. Three kinds of defenses are real defenses. These are defenses derived from the nature of the obligation. A real defense is a total defense. It benefits all the debtors. 2 personal defenses. Personal defenses may either be total or partial defenses. An example of a total personal defense is if the consent of the debtors were all vitiated. An example of a partial defense is that a certain amount is not yet due. It is partial since there may be amounts which are already due. Thus, the debtor has to pay for those amounts which are due. 3 defenses which are personal to the other co-debtors. The debtor can only avail himself of these defenses only with regard to the part of the debt which his co-debtors are responsible for. These defenses are partial. The debtor sued can invoke all 3 kinds of defenses. The difference is whether such defense would result in total or partial exculpation. For according to performance, Articles 1223 to 1225. Art. 1223 The divisibility or indivisibility of the things that are the object of obligations in which there is only one debtor and only one creditor does not alter or modify the provisions of Chapter 2 of this title. Art. 1224 A joint indivisible obligation gives rise to indemnity for damages from the time any one of the debtors does not comply with his undertaking. The debtors who may have been ready to fulfill their promises shall not contribute to the indemnity beyond the corresponding portion of the price of the thing or of the value of the service in which the obligation consists. Art. 1225 For the purposes of the preceding articles, obligations to give definite things and those which are not susceptible of partial performance shall be deemed to be indivisible. When the obligation has for its object the execution of a certain number of days of work, the accomplishment of work by metrical units, or analogous things which by their nature are susceptible of partial performance, it shall be divisible. However, even though the object or service may be physically divisible, an obligation is indivisible if so provided by law or intended by the parties. In obligations not to do, divisibility or indivisibility shall be determined by the character of the prestation in each particular case. Divisible and indivisible obligations have nothing to do with the object of the prestation. A common misconception is if the object of the prestation is divisible, then the obligation is also divisible. Indivisible. An obligation is divisible when it is susceptible to partial performance. Be indivisible. An obligation is indivisible when it cannot be validly performed in parts. General rule: obligations are indivisible. Exceptions. I. When the parties provide otherwise, Articles 1225, 3rd, 1248. 2. When the nature of the obligation necessarily entails the performance of the obligation in parts. Example: hiring a security guard to guard from 8 p.m. to 2 a.m. daily for 6 months. This obligation cannot be performed indivisibly. You can't compress time. When the obligation has for its object the execution of a certain number of days of work, the accomplishment of work by metrical units, or analogous things, which by their nature are susceptible of partial performance, it shall be divisible. Article 1225, 2nd. Exception to the exception, however, even though the object or service may be physically divisible, an obligation is indivisible if 1. So provided by law, or 2. Intended by the parties. 3. When the law provides otherwise. There are provisions on payment which provide that performance may be divisible. Divisibility of the object does not mean that the obligation is also divisible. But indivisibility of the object necessarily means an indivisible obligation. Art. 1248. Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. The test of divisibility of an obligation is whether or not it is susceptible of partial performance. For example, if X is supposed to deliver 1,000 kilos of sugar, this does not mean that X can deliver the sugar in installments. 5. According to sanction for breach, Articles 1226 to 1230. Art. 1226. In obligations with a penal clause, the penalty shall substitute the indemnity for damages and the payment of interests in case of non-compliance, if there is no stipulation to the contrary. Nevertheless, damages shall be paid if the obliger refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. The penalty may be enforced only when it is demandable in accordance with the provisions of this code. Art. 1227. The debtor cannot exempt himself from the performance of the obligation by paying the penalty, save in the case where this right has been expressly reserved for him. Neither can the creditor demand the fulfillment of the obligation and the satisfaction of the penalty at the same time, unless this right has been clearly granted him. However, if after the creditor has decided to require the fulfillment of the obligation, the performance thereof should become impossible without his fault, the penalty may be enforced. Art. 1228. Proof of actual damages suffered by the creditor is not necessary in order that the penalty may be demanded. Art. 1229. The judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor. Even if there has been no performance, the penalty may also be reduced by the courts if it is iniquitous or unconscionable. Art. 1230. The nullity of the penal clause does not carry with it that of the principal obligation. The nullity of the principal obligation carries with it that of the penal clause. A. No penal clause. B. With penal clause. A penal clause is an accessory undertaking to assume greater liability in case of breach. SSS vs. Moonwalk. Penal clauses are governed by Articles 2226 to 2228, the provisions on liquidated damages. Since a penal clause is the same as liquidated damages, Lambert vs. Fox. Penal clauses may be reduced by the courts if unconscionable. Two functions of a penal clause, SSS vs. Moonwalk, I. To provide liquidated damages. The creditor can demand liquidated damages without having to prove actual damages. The only limitation that the courts will reduce the liquidated damages if the same is scandalously unconscionable. 2. To strengthen the coercive force of the obligation by the threat of greater responsibility in case of breach. Stipulates a penalty which is greater than one without a penal clause. Thus, Robes Francisco states that 4% interest is not a penal clause. 2. Characteristics of a penal clause. I. Subsidiary or alternative, Article 1227. General rule: upon breach of the obligation, the creditor has to choose whether to demand the principal or the penalty. Exception: the principal obligation and the penalty can be demanded when the penal clause is joint or cumulative. This occurs when it is the creditor has been clearly granted such right, Article 1227, second sentence, either expressly or impliedly. The implied right must be one ascertainable from the nature of the obligation. An example is in the construction industry, where the contractor must pay the penalty if the work is completed after the stipulated time frame but must also finish the agreed construction. 2. Exclusive, Article 1226. General rule: the penalty clause takes the place of other damages. That's why in imposing a penalty clause, make sure that the penalty is stiff. Exception: both the penalty and actual damages may be recovered in the following: 1. Express stipulation. 2. Refusal by the debtor to pay the penalty. 3. The debtor is guilty of fraud, malice, in the performance of the obligation. Art. 2226. Liquidated damages are those agreed upon by the parties to a contract, to be paid in case of breach thereof. Art. 2227. Liquidated damages, whether intended as an indemnity or a penalty, shall be equitably reduced if they are iniquitous or unconscionable. Art. 2228. When the breach of the contract committed by the defendant is not the one contemplated by the parties in agreeing upon the liquidated damages, the law shall determine the measure of damages, and not the stipulation. In Pamintuan v. SCA, the Supreme Court said that the excess of damages absorbs the penalty. Professor Balain said that this is a wrong application. You can demand both the excess and the penalty. Extinguishment of Obligations. Art. 1231. Obligations are extinguished. 1. By payment or performance. 2. By the loss of the thing due. 3. By the condonation or remission of the debt. 4. By the confusion or merger of the rights of creditor and debtor. 5. By compensation. 6. By novation. Other causes of extinguishment of obligations, such as annulment, rescission, fulfillment of a resolutory condition, and prescription, are governed elsewhere in this code. 1. Payment or performance, Articles 1232 to 1251. Art. 1232. Payment means not only the delivery of money but also the performance, in any other manner, of an obligation. Art. 1233. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Art. 1234. If the obligation has been substantially performed in good faith, the obliger may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. Art. 1235. When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. Art. 1236. The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation, unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. Art. 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the latter, cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. Art. 1238. Payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires the debtor's consent. But the payment is in any case valid as to the creditor who has accepted it. Art. 1239. In obligations to give, payment made by one who does not have the free disposal of the thing due and capacity to alienate it shall not be valid, without prejudice to the provisions of Article 1427 under the title on Natural Obligations. Art. 1240. Payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. Art. 1241. Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered, or insofar as the payment has been beneficial to him. Payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor. Such benefit to the creditor need not be proved in the following cases. 1. If after the payment, the third person acquires the creditor's rights. 2. If the creditor ratifies the payment to the third person. 3. If by the creditor's conduct, the debtor has been led to believe that the third person had authority to receive the payment. Art. 1242 Payment made in good faith to any person in possession of the credit shall release the debtor. Art. 1243 Payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall not be valid. Art. 1244 The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as, or more valuable than that which is due. In obligations to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obligee's will. Art. 1245 In payment, whereby property is alienated to the creditor in satisfaction of a debt in money, shall be governed by the law of sales. Art. 1246 When the obligation consists in the delivery of an indeterminate or generic thing, whose quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality. Neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. Art. 1247 Unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to judicial costs, the rules of court shall govern. Art. 1248 Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. Art. 1249 The payment of debts in money shall be made in the currency stipulated, and if it is not possible to deliver such currency, then in the currency which is legal tender in the Philippines. The delivery of promissory notes payable to order, or bills of exchange or other mercantile documents shall produce the effect of payment only when they have been cashed, or when through the fault of the creditor they have been impaired. In the meantime, the action derived from the original obligation shall be held in the abeyance. Art. 1250 In case an extraordinary inflation or deflation of the currency stipulated should supervene, the value of the currency at the time of the establishment of the obligation shall be the basis of payment, unless there is an agreement to the contrary. Art. 1251 Payment shall be made in the place designated in the obligation. There being no express stipulation and if the undertaking is to deliver a determinate thing, the payment shall be made wherever the thing might be at the moment the obligation was constituted. In any other case the place of payment shall be the domicile of the debtor. If the debtor changes his domicile in bad faith or after he has incurred in delay, the additional expenses shall be borne by him. These provisions are without prejudice to venue under the rules of court. Like obligee and creditor, payment and performance are twin terms. Payment refers to obligations to give while performance refers to obligations to do. Payment and performance is the paradigmatic mode. When obligations are entered into, the parties expect payment or performance. All other modes of extinguishing obligations are abnormal modes. Requisites of payment A. As to prestation I identity. Identity means that the very prestation must be performed. For example, if the obligation is to give a car, one cannot fulfill the obligation pay giving a house. If the prestation is specific, the debtor must give or deliver the specific thing which was agreed upon, Article 1244. If the prestation is generic, the creditor cannot demand a thing of superior quality. However, the debtor cannot give a thing of inferior quality, Article 1246. The payment of debts in money shall be made in the currency stipulated, and if it not possible to deliver such currency, then in the currency which is legal tender in the Philippines, Article 1249, first. RA number 529 has been repealed by RA number 8183 which allows payment in different currency. However, in the absence of an agreement, payment shall be made in P. Negotiable papers and other commercial documents can be refused by the creditor unless there is stipulation to the contrary. If the negotiable papers and other commercial documents are accepted by the creditor, it has only a provisional effect. There is payment only in the following, Article 1249, second. 1. When they have been honored and cashed, or 2. When through the fault of the creditor, they have been impaired. In the case of Namarco, the check must be the check of another person, not a party, before there will be impairment. For example, A gave B a check as payment for a loan. B did not encash the check, as a result of which, the check became stale. There is no impairment here. B can still ask A for payment of the loan. However, if B endorsed a check made by A to C as payment for a loan and C did not encash the check which became stale, then C can no longer ask B to pay him again. In the case of Pacific Timber, the Supreme Court said that a certified check or a manager's check is considered as good as cash. But newer cases say that such instruments are not considered legal tender and thus, the creditor can refuse to accept. For example, A gives B a manager's check and bank closes for a bank holiday. Article 1250 was applied only during the Japanese occupation. Exceptions to the requirement of identity 1. Dation and Pago, Article 1245. Art. 1245 Dation in payment, whereby property is alienated to the creditor in satisfaction of a debt in money, shall be governed by the law of sales. 2. Novation 2. Integrity. Identity means that the entire prestation must be performed. Completeness, Article 1233. Exceptions to integrity. 1. Substantial compliance in good faith. Article 1234. Art. 1234 If the obligation has been substantially performed in good faith, the obliger may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. 2. Waiver, Article 1235. Art. 1235 When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. 3. In application of payments if the debts are equally onerous, Article 1254, second. Art. 1254, second. If the debts due are of the same nature and burden, the payment shall be applied to all of them proportionately. Art. 1250 In case an extraordinary inflation or deflation of the currency stipulated should supervene, the value of the currency at the time of the establishment of the obligation shall be the basis of payment, unless there is an agreement to the contrary. Art. 1233 A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. 3. Indivisibility. Indivisibility means that the obliger must perform the prestation in one act and not in installments, Article 1248. The creditor can validly refuse if the performance is not in one act. Exceptions to indivisibility, cases when the law allows installment performance. 1. In case of express stipulation, Article 1248. Art. 1248 Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. 2. In prestations which necessarily entail partial performance, Article 1225, second. Art. 1225, second. When the obligation has for its object the execution of a certain number of days of work, the accomplishment of work by metrical units, or analogous things which by their nature are susceptible of partial performance, it shall be divisible. 3. If the debt is liquidated in part and unliquidated in part. Article 1248. Art. 1248. Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. 4. In joint divisible obligations, Article 1208. Art. 1208. If from the law, or the nature or the wording of the obligations to which the preceding article refers the contrary does not appear, the credit or debt shall be presumed to be divided into as many shares as there are creditors or debtors, the credits or debts being considered distinct from one another, subject to the rules of court governing the multiplicity of suits. 5. In solidary obligations, when the debtors are bound under different terms and conditions, Article 1211. Art. 1211. Solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. 6. In compensation where there is a balance left, Article 1290. Art. 1290. When all the requisites mentioned in Article 1279 are present, compensation takes effect by operation of law, and extinguishes both debts to the concurrent amount, even though the creditors and debtors are not aware of the compensation. 7. If the work is to be delivered partially, the price or compensation for each part having been fixed. Article 1720. Art. 1720. The price or compensation shall be paid at the time and place of delivery of the work, unless there is a stipulation to the contrary. If the work is to be delivered partially, the price or compensation for each part having been fixed, the sum shall be paid at the time and place of delivery, in the absence of stipulation. 8. In case of several guarantors who demand the right of division, Article 2065. Art. 2065. Should there be several guarantors of only one debtor and for the same debt, the obligation to answer for the same is divided among all. The creditor cannot claim from the guarantors except the shares which they are respectively bound to pay, unless solidarity has been expressly stipulated. The benefit of division against the co-guarantors ceases in the same cases and for the same reasons as the benefit of excussion against the principal debtor. 9. In case of impossibility or extreme difficulty of a single performance. For example, A is obligated to deliver 1 million bags of cement. Under the circumstances, this may be extremely difficult. B is to the parties. I payer, obliger, debtor who may be the payer. 1. Without the consent of the creditor A. The debtor himself. B. The debtor's heirs or assigns C. The debtor's agent. D. Anyone interested in the fulfillment of the obligation. E.g. guarantor. 2. With the consent of the creditor. Anyone can pay if the creditor consents. Effect of payment by a third person. 1. Payment was with the debtor's consent. General rule: the payer steps into the shoes of the creditor and becomes entitled not only to recover what he has paid, but also to exercise all the rights which the creditor could have exercised. Subrogation. Articles 1236, 1237. There is no extinguishment of the obligation but a change in the active subject. Exception: no subrogation if intended to be a donation. Article 1238. 2. Payment was without the debtor's consent. The third person may demand repayment to the extent that the debtor has benefited. Article 1236, second. 2. Payee, obligee, creditor who may be the payee. 1. The creditor himself. Articles 1240, 1626, 2. The creditor's successor or transferee. Article 1240. Art. 1236 The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation, unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. Art. 1237 Whoever pays on behalf of the debtor without the knowledge or against the will of the latter, cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. Art. 1238 Payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires the debtor's consent. But the payment is in any case valid as to the creditor who has accepted it. Art. 1240 Payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. Art. 1626 The debtor who, before having knowledge of the assignment, pays his creditor shall be released from the obligation. 3. The creditor's agent, Article 1240. For any third person subject to the following conditions, provided it redounded to the creditor's benefit and only to the extent of such benefit, Article 1241, 2nd par. B. If it falls under Article 1241 2, 1, 2, and 3, the benefit is total. 5. Anyone in possession of the credit, Article 1242, 6. In all these 5 instances, it is required that the debt should not be garnished, Article 1242. If there is payment despite garnishment, then there is no payment. C. As to the time and place of performance. I. When payment should be made. Payment should be made when it is due. Even if the payment is due, the general rule is that demand is still necessary. Article 1169 provides the instances when demand is not necessary. 1. When the obligation or the law expressly so declares. 2. Time is the controlling motive for the establishment of the contract. 3. Demand would be useless to. Where payment should be made. Primary rule, agreement of the parties. Art. 1241. Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered, or insofar as the payment has been beneficial to him. Payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor. Such benefit to the creditor need not be proved in the following cases: 1. If after the payment, the third person acquires the creditor's rights. 2. If the creditor ratifies the payment to the third person. 3. If by the creditor's conduct, the debtor has been led to believe that the third person had authority to receive the payment. Art. 1242 Payment made in good faith to any person in possession of the credit shall release the debtor. Art. 1169 Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary in order that delay may exist. 1. When the obligation or the law expressly so declare, or 2. When from the nature and the circumstances of the obligation it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract, or 3. When demand would be useless, as when the obliger has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, delay by the other begins. Secondary rule, place where the thing was at the time the obligation was constituted if the obligation is to deliver a determinate thing. Tertiary rule, debtor's domicile, not residence. 4 Special forms of payment: datation and pago, Article 1245. Art. 1245 In payment, whereby property is alienated to the creditor in satisfaction of a debt in money, shall be governed by the law of sales. Dation en pago is the act of extinguishing the obligation by the substitution of payment. It is the delivery and transmission of ownership of a thing by the debtor to the creditor as an accepted performance/payment of an obligation. By agreement of the parties, the prestation is changed. Dation en pago is a special form of payment since it does not comply with the requisite of identity. Other terms for dation en pago include dation in payment, dation en paiement and datio in solitum. Dation en pago is governed by the Law on Sales, Article 1245. There are two ways of looking at dation en pago. The traditional way is to view dation en pago as a sale. Example, A owes BP 100,000. A has no cash when the loan falls due, but he offers the car if B wants it. B accepts. Here, the debt is in money but payment is in something else. According to the old traditional concept, it is like a sale because P 100,000 seemed to be the purchase price and the car is the object. However, the modern view is to look at dation en pago as a novation. Castan has another view of dation en pago. He believes that it is neither a sale nor a novation but a special form of payment. It is a species/variation of payment implying an onerous transaction similar to but not equal to a sale. It is not novation since there is no new obligation. Dation en pago will take place only if the parties consent. Dation en pago extinguishes the obligation up to the value of the thing delivered unless the parties agree that the entire obligation is extinguished. Lopez vs. CA. B. Application of Payments, Articles 1252 to 1254. Art. 1252. He who has various debts of the same kind in favor of one and the same creditor, may declare at the time of making the payment, to which of them the same must be applied. Unless the parties so stipulate, or when the application of payment is made by the party for whose benefit the term has been constituted, application shall not be made as to debts which are not yet due. If the debtor accepts from the creditor a receipt in which an application of the payment is made, the former cannot complain of the same, unless there is a cause for invalidating the contract. Art. 1253. If the debt produces interest, payment of the principal shall not be deemed to have been made until the interests have been covered. Art. 1254. When the payment cannot be applied in accordance with the preceding rules, or if application cannot be inferred from other circumstances, the debt which is most onerous to the debtor, among those due, shall be deemed to have been satisfied. If the debts due are of the same nature and burden, the payment shall be applied to all of them proportionately. Application payment is the designation of the debt which is being paid by a debtor who has several obligations of the same kind in favor of the creditor to whom payment is made. The situation in application of payments is that a debtor owes his creditor. There are several debts due, but the debtor cannot pay all of the debts due. Example, A owes BP 2000, P 3000, and P 10,000. A gives BP 15,000. There is no application of payment here because it is equal to the total amount due. The creditor can always not accept application of payments since the creditor cannot be compelled to accept partial performance of the obligation. However, this may not be wise since the debtor may have other creditors. The rules on application of payment solve the problem of distributing the payment which is less than the total obligation. Rules in application of payment. 1. St. Rule, apply in accordance with the agreement. 2. Nd. Rule, if there is no agreement, the debtor has the right to apply. 3. Rd. Rule, if the debtor does not choose, the creditor can choose. 4. Th. Rule, apply to the most onerous debt, Article 1254. 1. Rules to determine which is the more onerous obligation. An interest-bearing obligation is more onerous than a non-interest-bearing obligation. 2. An older debt is more onerous than a recent debt. 3. An obligation where the party is bound as a principal is more onerous than an obligation is bound as a surety. 4. An obligation which is secured is more onerous than an obligation which is unsecured. v. An obligation with a penal clause is more onerous than an obligation without a penal clause. 5th Rule, if equally onerous, apply proportionately. Article 1254, 2. See Payment by Cession, Article 1255. Art. 1255 The debtor may cede or assign his property to his creditors in payment of his debts. This cession, unless there is stipulation to the contrary, shall only release the debtor from responsibility for the net proceeds of the thing assigned. The agreements which, on the effect of the cession, are made between the debtor and his creditors shall be governed by special laws. The situation is contemplated here is that the debtor has several creditors and several debts. He turns over property to his creditors who are given the authority to sell the property and to apply the proceeds to his debt. In payment by cession, property is turned over by the debtor to the creditors who acquire the right to sell it and divide the net proceeds among themselves. In payment by cession, the creditors do not own the property to be sold. The creditors only have the power to sell. The net proceeds of the sale will be distributed according to the agreement. Payment by cession is a special form of payment because there is no completeness of performance, integrity. In most cases, there will be a balance due. Payment by cession distinguished from dation and pago. In dation and pago, there is a transfer of ownership from the debtor to the creditor. In payment by cession, there is no transfer of ownership. The creditors simply acquire the right to sell the properties of the debtor and apply the proceeds of the sale to the satisfaction of their credit. Payment by cession does not generally terminate all debts due since normally there is still a balance due. The balance will continue to be due unless the parties agree otherwise. Usually, the termination is only to the extent of the net proceeds. The extinguishment of the obligation is pro tanto. Payment by cession must be distinguished from insolvency. Two kinds of insolvency: extrajudicial or voluntary. In extrajudicial insolvency, if there is a balance left, the debtor must still pay. However, the debtor may limit which properties will be sold by the creditors since the agreement is contractual. 2. Judicial. In judicial insolvency, the obligation is totally extinguished even if there's still a balance. In judicial insolvency, every property which is not exempt from attachment or execution is made available for sale. Detender of payment in consignation, Article 1256 to 1261, Art. 1256. If the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. Consignation alone shall produce the same effect in the following cases. 1. When the creditor is absent or unknown, or does not appear at the place of payment. 2. When he is incapacitated to receive the payment at the time it is due. 3. When, without just cause, he refuses to give a receipt. 4. When two or more persons claim the same right to collect. 5. When the title of the obligation has been lost. Art. 1257. In order that the consignation of the thing due may release the obliger, it must first be announced to the persons interested in the fulfillment of the obligation. The consignation shall be ineffectual if it is not made strictly in consonance with the provisions which regulate payment. Art. 1258. Consignation shall be made by depositing the things due at the disposal of judicial authority, before whom the tender of payment shall be proved, in a proper case, and the announcement of the consignation in other cases. The consignation having been made, the interested parties shall also be notified thereof. Art. 1259. The expenses of consignation, when properly made, shall be charged against the creditor. Art. 1260. Once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation. Before the creditor has accepted the consignation, or before a judicial declaration that the consignation has been properly made, the debtor may withdraw the thing or the sum deposited, allowing the obligation to remain in force. Art. 1261. If, the consignation having been made, the creditor should authorize the debtor to withdraw the same, he shall lose every preference which he may have over the thing. The co-debtors, guarantors, and sureties shall be released. Consignation is the act of depositing the thing due with the court or judicial authorities whenever the creditor cannot accept or refuses to accept payment, and it generally requires a prior tender of payment. It is defined in the case of Soko vs. Militant as a deposit of the object of the prestation in a competent court in accordance with the rules prescribed by law, after tender of payment was refused or circumstances which render payment impossible or inadvisable. According to Professor Balain, the title of the subsection is wrong. It should have been consignation only because that is the special mode of payment and not the tender of payment. Tender of payment is a manifestation made by the debtor of his willingness, readiness, and ability to pay. It is a special mode of payment because payment is made not to the creditor but to the court. Consignation is an option on the part of the debtor because consignation assumes that the creditor was in mora accipiendi when the creditor without just cause refuses to accept payment. Of course, if the creditor without just cause refuses to accept payment, the debtor may just delay payment. But something still hangs above his head. He is therefore given the option to consign. Requisites. I. That there was a debt due. 2. That the consignation of the obligation had been made because of some legal cause, either because 1. Tender of payment was unjustly refused by the creditor, or 2. There is no need for tender of payment due to circumstances which make tender of payment impossible or inadvisable. Circumstances which make tender of payment unnecessary, Article 1256. A. The creditor was absent or unknown, or does not appear at the place of payment. B. The creditor was incapacitated to receive the payment at the time it was due. Payment made to an incapacitated person does not count except to the extent that the incapacitated person is benefited. C. The creditor, without just cause, refuses to give a receipt. According to Professor Balain, this is wrong. This is not a special case wherein you don't need tender of payment. This presupposes that there has been a prior tender of payment. D. Several persons claimed to be entitled to receive the amount due. The debtor should file interpleader with consignation. E. The title of the obligation has been lost. 3. That previous notice of the consignation had been given to the person interested in the performance of the obligation. Article 1257. 4. That the amount due was placed at the disposal of the court. Consignation proper. V. That after the consignation had been made the person interested was notified thereof, second notice. Failure of any of these requirements is enough ground to render a consignation ineffective. 2. Loss of the thing due, Articles 1262 to 1269. Art. 1262. An obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor, and before he has incurred in delay. When by law or stipulation, the obliger is liable even for fortuitous events, the loss of the thing does not extinguish the obligation, and he shall be responsible for damages. The same rule applies when the nature of the obligation requires the assumption of risk. Art. 1263. In an obligation to deliver a generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation. Art. 1264. The courts shall determine whether, under the circumstances, the partial loss of the object of the obligation is so important as to extinguish the obligation. Art. 1265. Whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault, unless there is proof to the contrary, and without prejudice to the provisions of Article 1165. This presumption does not apply in case of earthquake, flood, storm, or other natural calamity. Art. 1266. The debtor in obligations to do shall also be released when the prestation becomes legally or physically impossible without the fault of the obliger. Art. 1268. When the debt of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause for the loss, unless the thing having been offered by him to the person who should receive it. The latter refused without justification to accept it. Art. 1269. The obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third persons by reason of the loss. Loss of the thing here is not to be taken in the strict legal meaning of loss. Loss can be applied in an obligation to give a determinate thing, Article 1262, in an obligation to give a generic thing, Article 1263, and in an obligation to do, Article 1266. The term loss embraces all causes which may render impossible the performance of the prestations, impossibility of performance. A thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. When the debt of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause for the loss, unless the thing having been offered by him to the person who should receive it. The latter refused without justification to accept it, Article 1268. Kinds of impossibility according to time. A. Original impossibility. If the impossibility had already existed when the contract was made, then the result is not extinguishment but inefficacy of the obligation under Articles 1348 and 1493. The contract is void. B. Supervening impossibility. The impossibility of performance must be subsequent to the execution of the contract in order to extinguish the obligation. Change in the circumstances. Rebus sic stantibus literally means, things as they stand. It is short for clausula rebus sic stantibus, agreement of things as they stand. Also called risgo. Art. 1348. Impossible things or services cannot be the object of contracts. Art. 1493. If at the time the contract of sale is perfected, the thing which is the object of the contract has been entirely lost, the contract shall be without any effect. But if the thing should have been lost in part only, the vendee may choose between withdrawing from the contract and demanding the remaining part, paying its price in proportion to the total sum agreed upon. Imprevisible, Spanish, Theorie de Imprévision, French, and Verschuwenden de Grundgeschäfts, German. Art. 1267. When the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obliger may also be released therefrom, in whole or in part. In Roman law, no matter how difficult the obligation is, it has to be performed or else the obliger may be liable for damages, pacta sunt servanda. In medieval times, although agreements should be complied with, in certain extreme circumstances, the debtor can be released because of the difficulty in performance. This is a principle of international law which holds that when two states enter into a treaty, they enter taking into account the circumstances at the time it was entered into, and should the circumstances change as to make the fulfillment of the treaty very difficult, one may ask for a termination of the treaty. This principle of international law has spilled over into civil law. The underlying philosophy here is that when parties enter into an agreement, the parties contemplate existing circumstances. When things supervene, the parties may be discharged because they did not contemplate such difficult circumstances. This doctrine is also called the doctrine of extreme difficulty and frustration of commercial object or enterprise. The attitude of the courts on this doctrine is very strict. This principle has always been strictly applied. To give it a liberal application is to undermine the binding force of an obligation. Every obligation is difficult. The performance must be extremely difficult in order for rebus sic stantibus to apply. Requisites. I. The event or change could not have been foreseen at the time of the execution of the contract. 2. The event or change makes the performance extremely difficult but not impossible. 3. The event must not be due to an act of either party. 4. The contract is for a future prestation. If the contract is of immediate fulfillment, the gross inequality of the reciprocal prestation may involve lesion or want of cause. Obligation to give. A. Obligation to give a determinate thing. The happening of a fortuitous event in itself does not necessarily extinguish an obligation to deliver a determinate thing. An obligation consisting in the delivery of a specified thing shall be extinguished when the said thing is lost or destroyed without the fault of the obliger and before he is in default. Whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault, unless there is proof to the contrary, and without prejudice to the provisions of Article 1165. This presumption does not apply in case of earthquake, flood, storm, or other natural calamity. Article 1265. Be obligation to give a generic thing. The happening of a fortuitous event does not extinguish the obligation to deliver a generic thing. Genus non quam perit, genus never perishes. This is the general rule. Sometimes, though, the entire genus perishes because it becomes illegal. What is not covered by this rule is an obligation to deliver a limited generic. Example: I promise to deliver to you one of my amor solos, I have 4. This is not generic because I only have 4, but not specific because I did not specify which one. This is governed by Article 1262. In this case, the obligation may be extinguished by the loss of all the things through fortuitous event. Obligation to do. The debtor in obligations to do shall also be released when the prestation becomes legally or physically impossible without the fault of the obliger, Article 1266. The impossibility here must be supervening. If it is original, then the contract is void. Kinds of impossibility according to nature. A. Objective impossibility. In objective impossibility, the act cannot be done by anyone. The effect of objective impossibility is to extinguish the obligation. B. Subjective impossibility. In subjective impossibility, the obligation becomes impossible only with respect to the obliger. There are 3 views as to the effect of a subjective impossibility. I. The obligation is not extinguished. The obliger should ask another to do the obligation. 2. The obligation is extinguished. 3. A third view distinguishes one prestation which is very personal and one which are not personal, such that subjective impossibility is a cause for extinguishes a very personal obligation but not an obligation which is not very personal. Effect of loss on creditor's rights. The obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against the third person by reason of the loss. A common example of this is insurance. 3. Condonation or remission of the due. Art. 1270. Condonation or remission is essentially gratuitous, and requires the acceptance by the obliger. It may be made expressly or impliedly. One and the other kind shall be subject to the rules which govern in officious donations. Express condonation shall, furthermore, comply with the forms of donation. Art. 1271. The delivery of a private document evidencing a credit, made voluntarily by the creditor to the debtor, implies the renunciation of the action which the former had against the latter. If in order to nullify this waiver it should be claimed to be inofficious, the debtor and his heirs may uphold it by proving that the delivery of the document was made in virtue of payment of the debt. Art. 1272. Whenever the private document in which the debt appears is found in the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily, unless the contrary is proved. Art. 1273. The renunciation of the principal debt shall extinguish the accessory obligations, but the waiver of the latter shall leave the former in force. Art. 1274. It is presumed that the accessory obligation of pledge has been remitted when the thing pledged, after its delivery to the creditor, is found in the possession of the debtor, or of a third person who owns the thing. Condonation or remission is an act of liberality by virtue of which, without receiving any equivalent, the creditor renounces enforcement of an obligation which is extinguished in whole or in part. Requisites. The debt must be existing. You can remit a debt even before it is due. Example: I owe AP1M. I promised to pay on July 31, 2002 with interest. On May 31, I condones the obligation. The obligation is existing but not yet due, but it can be condoned. B. The renunciation must be gratuitous. If renunciation is for a consideration, the mode of extinguishment may be something else. It may be novation, compromise, ordation, and pago, for example. C. There must be acceptance by the debtor. D. The parties must have capacity. The creditor must have capacity to give away. The debtor must have capacity to accept. Form. A. If the renunciation is express, then it is a donation. The form of donation must be observed. If the condonation involves movables, apply Article 748. If it involves immovables, apply Article 749. B. If the renunciation is implied, then it is tantamount to a waiver. There is no prescribed form in a waiver, Article 6. For example, the creditor can just refuse to collect the debt. According to Professor Balain, Articles 1271 and 1272 refer to a kind of implied renunciation when the creditor divests himself of the proof credit. The delivery of a private document, evidencing a credit, made voluntarily by the creditor to the debtor, implies the renunciation of the action which the former had against the latter. If in order to nullify this waiver it should be claimed to be inofficious, the debtor and his heirs may uphold it by providing that the delivery of the document was made in virtue of payment of the debt, Article 1271. Article 1271 has no application to public documents because there is always a copy in the archives which can be used to prove the credit. Private document refers to the original in order for Article 1271 to apply. By delivering the private document, the creditor deprives himself of proof. The second paragraph of Article 1271 implies that the voluntary return of the title of credit is presumed to be by Art. 748. The donation of a movable may be made orally or in writing. An oral donation requires the simultaneous delivery of the thing or of the document representing the right donated. If the value of the personal property donated exceeds 5,000 pesos, the donation and the acceptance shall be made in writing, otherwise, the donation shall be void. 632a. Art. 749. In order that the donation of an immovable may be valid, it must be made in a public document, specifying therein the property donated and the value of the charges which the donee must satisfy. The acceptance may be made in the same deed of donation or in a separate public document, but it shall not take effect unless it is done during the lifetime of the donor. If the acceptance is made in a separate instrument, the donor shall be notified thereof in an authentic form, and this step shall be noted in both instruments. Art. 6. Rights may be waived, unless the waiver is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. Art. 1271. The delivery of a private document evidencing a credit, made voluntarily by the creditor to the debtor, implies the renunciation of the action which the former had against the latter. If in order to nullify this waiver it should be claimed to be inofficious, the debtor and his heirs may uphold it by proving that the delivery of the document was made in virtue of payment of the debt. 1188. Art. 1272. Whenever the private document in which the debt appears is found in the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily, unless the contrary is proved. Reason of remission and not by reason of the payment of debt. According to Professor Balain, this is anomalous. This provision is absurd and immoral in that it authorizes the debtor and his heirs to prove that they paid the debt, when the provision itself assumes that there has been a remission, which is gratuitous. Whenever the private document in which the debt appears is found in the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily, unless the contrary is proved. Article 1272. 2 Presumptions. If a private document is found in the possession of the debtor, then it is presumed that the creditor voluntarily delivered it to him. 2. Since the creditor voluntarily delivered the private document, then there is a presumption of remission. Ways of remission. A. By will be. By agreement. Effect of partial remission. The renunciation of the principal debt shall extinguish the accessory obligations, but the waiver of the latter shall leave the former in force. Article 1273. Example, loan secured by a mortgage. If I condone the loan, I condone the mortgage. But if I condone the mortgage, I do not condone the loan, which merely becomes unsecured. The obligation of the guarantor is extinguished at the same time as that of the debtor, and for the same causes as all other obligations. Article 2076. The guarantors, even though they be solidary, are released from their obligation whenever by some act of the creditor they cannot be subrogated to the rights, mortgages, and preferences of the latter. Article 2080. It is presumed that the accessory obligation of pledge has been remitted when the thing pledged, after its delivery to the creditor, is found in the possession of the debtor, or of a third person who owns the thing. Article 1274. According to Professor Balain, the accessory obligation of pledge is extinguished because pledge is a possessory lien. The presumption in this case is that the pledgee has surrendered the thing pledged to the pledger. However, this is not a conclusive presumption according to Article 2110(2). This presumption is not applicable in a mortgage since there is no possessory lien. In addition to the requisites prescribed in Article 2085, it is necessary, in order to constitute the contract of pledge, that the thing pledged be placed in the possession of the creditor, or of a third person by common agreement. Article 2093. The debtor cannot ask for the return of the thing pledged against the will of the creditor, unless and until he has paid the debt and its interest, with expenses in a proper case. Article 2105. For confusion or merger of rights. Art. 1275. The obligation is extinguished from the time the characters of creditor and debtor are merged in the same person. Art. 1276. Merger which takes place in the person of the principal debtor or creditor benefits the guarantors. Confusion which takes place in the person of any of the latter does not extinguish the obligation. Art. 1277. Confusion does not extinguish a joint obligation except as regards the share corresponding to the creditor or debtor in whom the two characters concur. Confusion is the meeting in one person of the qualities of the creditor and debtor with respect to the same obligation. Confusion or merger of rights extinguishes the obligation because the creditor becomes his own debtor. Therefore, how can the creditor sue himself? Requisites of confusion. It must take place between the creditor and the principal debtor. Article 1276. A borrowed P1M from B with C as guarantor. If C acquires the right to collect the P1M, there is no confusion since C is neither a principal debtor or creditor. The effect is that the guarantee is extinguished. The principal obligation remains. B. The very same obligation must be involved. Article 1275. Usual causes of confusion. A succession, compulsory, testate, int estate, B. Donation. C. Negotiation of a negotiable instrument. Confusion can overlap with remission or payment. Example of confusion overlapping with remission, X owes OP 100,000. O bequeathed to X that credit. And then she died. In this case, there is extinguishment both by merger. But in this case, merger could overlap with remission. Example of confusion overlapping with payment. A makes a promissory note and endorses it to B. B endorsed it to C. C to D. D endorsed it back to A. 5. Compensation. Art. 1278. Compensation shall take place when two persons, in their own right, are creditors and debtors of each other. Art. 1279. In order that compensation may be proper, it is necessary 1. That each one of the obligers be bound principally, and that he be at the same time a principal creditor of the other. 2. That both debts consist in a sum of money, or if the things due are consumable, they be of the same kind, and also of the same quality if the latter has been stated. 3. That the two debts be due. 4. That they be liquidated and demandable. 5. That over neither of them there be any retention or controversy, commenced by third persons and communicated in due time to the debtor. Art. 1280. Notwithstanding the provisions of the preceding article, the guarantor may set up compensation as regards what the creditor may owe the principal debtor. Art. 1281. Compensation may be total or partial. When the two debts are of the same amount, there is a total compensation. Art. 1282. The parties may agree upon the compensation of debts which are not yet due. Art. 1283. If one of the parties to a suit over an obligation has a claim for damages against the other, the former may set it off by proving his right to said damages and the amount thereof. Art. 1284. When one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. Art. 1285. The debtor who has consented to the assignment of rights made by a creditor in favor of a third person, cannot set up against the assignee the compensation which would pertain to him against the assignor, unless the assignor was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. If the creditor communicated the cession to him but the debtor did not consent thereto, the latter may set up the compensation of debts previous to the cession, but not of subsequent ones. If the assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same and also later ones until he had knowledge of the assignment. Art. 1286. Compensation takes place by operation of law, even though the debts may be payable at different places, but there shall be an indemnity for expenses of exchange or transportation to the place of payment. Art. 1287. Compensation shall not be proper when one of the debts arises from a depositum or from the obligations of a depositary or of a bailee in comodatum. Neither can compensation be set up against a creditor who has a claim for support due by gratuitous title, without prejudice to the provisions of paragraph 2 of Article 301. Art. 1288. Neither shall there be compensation if one of the debts consists in civil liability arising from a penal offense. Art. 1289. If a person should have against him several debts which are susceptible of compensation, the rules on the application of payments shall apply to the order of the compensation. Art. 1290. When all the requisites mentioned in Article 1279 are present, compensation takes effect by operation of law, and extinguishes both debts to the concurrent amount, even though the creditors and debtors are not aware of the compensation. Compensation is a mode of extinguishing, to the concurrent amount, the obligations of those persons who in their own right are reciprocally debtors and creditors of each other. Perhaps, next to payment, compensation is the most common mode of extinguishing an obligation. Compensation distinguished from confusion. In compensation, there are two parties and two debts, whereas in confusion, there are two debts and only one party. Kinds of compensation. A. Legal, Article 1279. Legal compensation takes place automatically by operation of law once all the requisites under Article 1279 are present. Requisites. I. The parties must be mutually debtors and creditors of each other in their own right and as principals. There can be no compensation if one party occupies only a representative capacity, i.e. agent. Likewise, there can be no compensation if in one obligation, a party is a principal obliger and in another obligation, he is a guarantor. 2. The things due must be fungible. Article 1279 uses the word consumable. This is wrong. The proper terminology is fungible, which refers to things of the same kind which in payment can be substituted for another. 3. The two debts must be due. 4. The two debts must be liquidated and demandable. Demandable means that the debts are enforceable in court, there being no apparent defenses inherent in them. The obligations must be civil obligations, excluding those that are purely natural. Before a judicial decree of rescission or annulment, a rescissible or voidable debt is valid and demandable, hence, it can be compensated. A debt is liquidated when its existence and amount are determined. and a debt is considered liquidated, not only when it is expressed already in definite figures with C do not require verification, but also when the determination of the exact amount depends only on a simple arithmetical operation. V. Neither of the debts must not be garnished. 6. Compensation must not be prohibited by law. Articles 1287, 1288 and 1794 are examples of when legal compensation is not allowed. Legal compensation is not allowed when there is conventional or facultative compensation. Effect of legal compensation. If a person should have against him several debts which are susceptible of compensation, the rules on the application of payments shall apply to the order of the compensation. Article 1289. When all the requisites mentioned in Article 1279 are present, compensation takes effect by operation of law, and extinguishes both debts to the concurrent amount, even though the creditors and debtors are not aware of the compensation. Article 1290. Be facultative. Articles 1287, 1288. Facultative compensation takes place when compensation is claimable by only one of the parties but not of the other. Compensation shall not be proper when one of the debts arises from a depositum or from the obligations of a depositary or of a bailii in comodatum. Neither can compensation be set up against a creditor who has a claim for support due by gratuitous title, without prejudice to the provisions of paragraph 2 of Article 301, Article 1287. The prohibition of compensation when one of the debts arises from a depositum or comodatum is based on justice. A deposit is made or a comodatum is given on the basis of confidence in the depositary or the borrower. It is therefore a matter of morality that the depositary or the borrower should in fact perform his obligation, otherwise, the trust or confidence of the depositor or lender would be violated. With respect to future support, to allow its extinguishment by compensation would defeat its exemption from attachment and execution. Article 205. Art. 1794. Every partner is responsible to the partnership for damages suffered by it through his fault, and he cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. However, the courts may equitably lessen this responsibility if through the partner's extraordinary efforts in other activities of the partnership, unusual profits have been realized. Family Code, and may expose the recipient to misery and starvation. However, support in arrears can be compensated. The depositary cannot set up compensation with respect to the things deposited to him. But the depositor can set up the compensation. Example: A is a warehouseman. B deposits 1,000 quidans of rice with A. B also owes A 1,000 kilos of rice. A cannot claim compensation but B can set up compensation. Neither shall there be compensation if one of the debts consists in civil liability arising from a penal offense. Article 1288. If one of the debts consists in civil liability arising from a penal offense, compensation would be improper and inadvisable because the satisfaction of such obligation is imperative. The person who has the civil liability arising from the crime cannot set up compensation. However, the offended party is entitled to set up compensation. See Conventional or Contractual, Article 1282. Contractual or conventional compensation takes place when parties agree to set off even if the requisites of legal compensation are not present. The parties may agree upon the compensation of debts which are not yet due. The parties may compensate by agreement any obligations, in W/C the objective requisites provided for legal compensation are not present. D. Judicial, Article 1283. Judicial compensation is compensation decreed by the court in a case where there is a counterclaim. If one of the parties to a suit over an obligation has a claim for damages against the other, the former may set it off by proving his right to said damages and the amount thereof. Effect of assignment, Article 1285. Situation. There are two credits, Credit I and Credit II. In Credit I, A is the creditor and B is the debtor. In Credit II, B is the creditor and A is the debtor. A wants to assign credit I to C. A cannot assign credit to since it is passive subjective novation. Can B now invoke against C the compensation of credit to? It depends. A if the assignment is with the debtor's, B's, consent. Debtor cannot set up compensation at all unless the right is reserved. B if the assignment is with the debtor's, B's, knowledge but without consent. The debtor can set up compensation with a credit already existing at the time of the assignment. C if the assignment is without the debtor's, B's, knowledge. Debtor can set up as compensation any credit existing at the time he acquired knowledge even if it arose after the actual assignment. 6. Novation. Art. 1291 obligations may be modified by 1. Changing their object or principal conditions. 2. Substituting the person of the debtor. 3. Subrogating a third person in the rights of the creditor. Art. 1292. In order that an obligation may be extinguished by another which substitute the same, it is imperative that it be so declared in unequivocal terms, or that the old and the new obligations be on every point incompatible with each other. Art. 1293. Novation which consists in substituting a new debtor in the place of the original one, may be made even without the knowledge or against the will of the latter, but not without the consent of the creditor. Payment by the new debtor gives him the rights mentioned in Articles 1236 and 1237. Art. 1294. If the substitution is without the knowledge or against the will of the debtor, the new debtor's insolvency or non. Creditor. A. C. B. Debtor. Debtor. Creditor. I. 2. Fulfillment of the obligations shall not give rise to any liability on the part of the original debtor. Art. 1295. The insolvency of the new debtor, who has been proposed by the original debtor and accepted by the creditor, shall not revive the action of the latter against the original obliger, except when said insolvency was already existing and of public knowledge, or known to the debtor. When the delegated his debt. Art. 1296. When the principal obligation is extinguished in consequence of a novation, accessory obligations may subsist only insofar as they may benefit third persons who did not give their consent. Art. 1297. If the new obligation is void, the original one shall subsist, unless the parties intended that the former relation should be extinguished in any event. Art. 1298. The novation is void if the original obligation was void, except when annulment may be claimed only by the debtor or when ratification validates acts which are voidable. Art. 1299. If the original obligation was subject to a suspensive or resolutory condition, the new obligation shall be under the same condition, unless it is otherwise stipulated. Art. 1300. Subrogation of a third person in the rights of the creditor is either legal or conventional. The former is not presumed, except in cases expressly mentioned in this code. The latter must be clearly established in order that it may take effect. Art. 1301. Conventional subrogation of a third person requires the consent of the original parties and of the third person. Art. 1302. It is presumed that there is legal subrogation. 1. When a creditor pays another creditor who is preferred, even without the debtor's knowledge. 2. When a third person, not interested in the obligation, pays with the express or tacit approval of the debtor. 3. When, even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays, without prejudice to the effects of confusion as to the latter's share. Art. 1303. Subrogation transfers to the persons subrogated the credit with all the rights thereto appertaining, either against the debtor or against third person, be they guarantors or possessors of mortgages, subject to stipulation in a conventional subrogation. Art. 1304. A creditor, to whom partial payment has been made, may exercise his right for the remainder, and he shall be preferred to the person who has been subrogated in his place in virtue of the partial payment of the same credit. Novation is the extinguishment of an obligation by the substitution or change of the obligation by a subsequent one which extinguishes or modifies the first, either by changing the object of principal conditions, or by substituting the person of the debtor, or by subrogating a third person in the rights of the creditor. Novation is the most unusual mode of extinguishing an obligation. It is the only mode whereby an obligation is extinguished and a new obligation is created to take its place. The other modes of extinguishing an obligation are absolute in the sense that the extinguishment of the obligation is total. Novation, on the other hand, is a relative mode of extinguishing an obligation. A compromise is a form of novation. The difference is that a compromise has some judicial participation. The effect of compromise is the same as novation. Classification of novation. A subjective or personal novation, change of one of the subjects I active subjective. This a change of creditor. This is also known as subrogation. Two kinds of subrogation. 1. Legal, Article 1302. It is presumed that there is legal subrogation, when a creditor pays another creditor who is preferred, even without the debtor's knowledge. B. When a third person, not interested in the obligation, pays with the express or tacit approval of the debtor. C. When, even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays, without prejudice to the effects of confusion as to the latter's share. 2. Conventional. Conventional subrogation of a third person requires the consent of the original parties and of the third person, Article 1301. Effect of subrogation. 1. A creditor, to whom partial payment has been made, may exercise his right for the remainder, and he shall be preferred to the person who has been subrogated in his place in virtue of the partial payment of the same credit. Article 1304. 2. Subrogation transfers to the person subrogated the credit with all the rights thereto appertaining, either against the debtor or against third persons, be they guarantors or possessors of mortgages, subject to stipulation in a conventional subrogation, Article 1303. 2. Passive subjective. This is a change of debtor. Types of passive subjective. 1. Expromission, Article 1293. In expromission the changing of the debtor is not upon the old debtor's initiative. It could be upon the initiative of the creditor or of the new debtor. This requires the consent of the creditor since the changing of the debtor may prejudice him. This requires the consent of the new debtor since he is the one who will pay. The consent of the old debtor is not required. The intent of the parties must be to release the old debtor. The release of the old debtor is absolute even if it turns out that the new debtor is insolvent. Cases of expromission are quite rare. 2. Delegation, Article 1295. In delegation the change is at the debtor's initiative. The consent of the old debtor, delegante, the new debtor, delegato, and the creditor, delegatario, are all required. The intent of the parties must be to release the old debtor. However, release of the old debtor is not absolute. He may be held liable. A. If the new debtor was already insolvent at the time of the delegation, and B. Such insolvency was either known to the old debtor or of public knowledge. B. Objective or real novation. In objective novation there is a change in the object or in the principal conditions. Novation by a change in the principal conditions is the most problematic kind of novation because one has to determine whether or not the change in the conditions is principal or merely incidental. If the amount of debt is increased, Castan thinks that there is a novation while Cagillo thinks there is no novation. Professor Balain thinks that Castan is correct. The old obligation is merged with the new. If the amount of the debt is decreased, according the SC in Sandico vs Peking, there is no novation. One can look at the decrease of the amount as a partial remission. In Miller vs CA, there is no novation if the terms of the payment are changed. In this case, there was a change from lump sum to installment payments. In Foy vs Yap, not only was the amount reduced, mode of payment was changed from single payment to installment. Finally, a mortgage was constituted. The SC said in Foy vs Yap that there was a novation. Therefore, a mere change in the amount or mode of payment if taken singly is not a novation. But taken together, there is a novation. In Inchosti vs. Iolo, the SC said that the mere extension of time is not a novation for the period does affects only the performance and not the creation of an obligation. In another case, the SC said that the shortening of the period is a novation. See mixed novation. Mixed is a combination of both subjective and objective novation. Requisites of novation. There must be a previous valid obligation. The novation is void if the original obligation was void, except when annulment may be claimed only by the debtor, or when ratification validates acts which are voidable. Article 1298, b. There must be an agreement of the parties to create the new obligation. If the original obligation was subject to a suspensive or resolutory condition, the new obligation shall be under the same condition, unless it is otherwise stipulated. Article 1299, c. There must be an extinguishment of the old obligation. Professor Balain considers this as an effect rather than a requisite of novation. In order that an obligation may be extinguished by another which substitute the same, it is imperative that it be so declared in unequivocal terms, or that the old and the new obligations be on every point incompatible with each other. Article 1292. D. The new obligation must be valid. If the new obligation is void, the original one shall subsist, unless the parties intended that the former relation should be extinguished in any event. Article 1297. Effect of novation. Accessory obligations may subsist only insofar as they may benefit third persons who did not give their consent. Example stipulation per autrui. General rule: in a novation, the accessory obligation is extinguished. Exception: in an active subjective novation, the guarantors, pledgers, mortgagors are not released. Under Article 1303, accessory obligations are not extinguished. So there is a conflict? How do you resolve? According to commentators, Article 1303 is an exception to Article 1296. BO's KP1MM is a guarantor of BB is substituted by UB is released. M is also released under Article 1296. M is released since he guarantees B's performance and not B's. B might have a good credit standing but U may not. M might be prejudiced if he has to guarantee U's performance. If there is a change in the creditor under Article 1303, the guarantor is not released since it doesn't make a difference. What the guarantor guarantees is the integrity of the debtor. 7. Annulment. 8. Rescission. 9. Fulfillment of a resolutory condition. 10. Prescription. 11. Death in certain instances. 12. For example, death extinguishes obligations which are purely personal, i.e. obligations in marriage, obligation to support, obligations in a partnership, etc. 13. Renunciation by the creditor, Article 6. The creditor waives the obligation. The renunciation need not be in any specific form. Renunciation and remission are two different things. A renunciation is a refusal by the creditor to enforce his claim with the intention of waiving it. A remission is in the nature of a donation. 14. Compromise. 15. Arrival of a resolutory term. 16. Mutual dissent or desistance, SORA vs DBP. 17. Unilateral withdrawal. General rule: unilateral withdrawals are not allowed. Exception: partnership. 18. Change of civil status. For example, if the marriage is annulled, certain obligations are extinguished, like the obligations to live together and to support one another. 19. Rebus sextantibus, Article 1267, 20. Want of interest. Example: A owns a Peking duck restaurant with a secret recipe for preparing Peking duck. A disclosed the secret recipe to B, his cook. B is then prohibited in his employment contract to work in another restaurant within 5 years from leaving A's restaurant. 2 years after B left, A closes his restaurant and opens a hardware store. B can now work in a restaurant. 21. Judicial insolvency. The effect of judicial insolvency is that all unpaid debts are written off for good. Thus, even if the debtor has improved his financial situation because of judicial insolvency, there is no need for the debtor to pay his unpaid debts. 2. Contracts. A general provisions. 1. Definition. Art. 1305. A contract is a meeting of the minds between two persons whereby one binds himself, with respect to the other, to give something or to render some service. Professor Balain thinks that the definition in Article 1305 is inaccurate. The term persons should be submitted by the term parties. Also, contracts may be multilateral, there can be more than two parties involved, i.e. partnership. 2 Characteristics of contracts. A. Obligatory force. Art. 1315. Contracts are perfected by mere consent, and from that moment the parties are bound not only to the fulfillment of what has been expressly stipulated but also to all the consequences which, according to their nature, may be in keeping with good faith, usage, and law. General rule: contracts are perfected by mere consent, the principle of consentiality, Article 1315. Exception: real contracts, such as deposit, pledge, and comodatum are not perfected until the delivery of the object of the obligation, Article 1316. Obligations arising from contracts have the force of law between the parties and should be complied with in good faith, Article 1159, Art. 1314. Any third person who induces another to violate his contract shall be liable for damages to the other contracting party. It is not clear whether Article 1314 is a tortious liability or a contractual liability. Professor Balain considers it as only a tortious liability, so it is not violative of the rule on relativity of contracts. Article 1314 is really a quasi-delict. Requisites. I. Existence of a valid contract. 2. Knowledge by the third person of the existence of the contract. 3. Interference by the third person in the contractual relation without legal justification. B. Mutuality. Art. 1308. The contract must bind both contracting parties, its validity or compliance cannot be left to the will of one of them. Art. 1309. The determination of the performance may be left to a third person, whose decision shall not be binding until it has been made known to both contracting parties. Art. 1310. The determination shall not be obligatory if it is evidently inequitable. In such case, the courts shall decide what is equitable under the circumstances. An example of a determination made by a third person, Article 1309, is the fixing of the price by the third person. The contract may be revoked if there is mutual dissent. C. Relativity. Art. 1311, 1. Contracts take effect only between the parties, their assigns and heirs, except in case where the rights and obligations arising from the contract are not transmissible by their nature, or by stipulation or by provision of law. The heir is not liable beyond the value of the property he received from the decedent. General rule: the contract is binding only upon the parties and their successors, Article 1311. However, if the contract is purely personal, intuito personae, then the contract will not bind assigns and heirs. Exception: 3 parties are affected by the contract in the following instances and can take appropriate action. I. Acción Pauliana, Article 1177. Art. 1177. The creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. An rescissory action involving a contract in fraud of creditors. Art. 1313. Creditors are protected in cases of contracts intended to defraud them. 2. Acción directa. A direct, not subrogatory, action by the creditor against his debtor's debtor, a remedy which gives the creditor the prerogative to act in his own name, such as the actions of the lessor against the sublessee, Article 1652. The laborer of an independent contractor against the owner, Article 1729 spade suit, the principal against the subagent, Article 1893. And the vendor a retro against the transferee of the vendee. Article 1608. 3. Article 1312. Art. 1312 in contracts creating real rights, third persons who come into possession of the object of the contract are bound thereby, subject to the provisions of the mortgage law and the land registration laws. 4. Stipulation por autrui, stipulation in favor of a third person. Art. 1311, 2. If a contract should contain some stipulation in favor of a third person, he may demand its fulfillment provided he communicated his acceptance to the obliger before its revocation. A mere incidental benefit or interest of a person is not sufficient. The contracting parties must have clearly and deliberately conferred a favor upon a third person. Requisites. 1. There must be a stipulation in favor of a third person. 2. That stipulation in favor of a third person should be a part and not the whole of the contract. 3. A clear and deliberate intent to confer a benefit on a third person and not merely incidental. In the case of Mandarin-Villa VSCA, the credit card holder was held to have a right to sue under the contract between the establishment and the bank. The Supreme Court said that it's a stipulation por autrui to confer benefit on the customer to purchase on credit. However, Professor Balain believes that it is debatable whether an agreement between a credit card company and establishment is a clear and deliberate conferment of benefit on a third party. He would have concurred with the decision in Mandarin-Villa if the basis was Quasi-Delict. Art. 1729. Those who put their labor upon or furnish materials for a piece of work undertaken by the contractor have an action against the owner up to the amount owing from the latter to the contractor at the time the claim is made. However, the following shall not prejudice the laborers, employees, and furnishers of materials. 1. Payments made by the owner to the contractor before they are due. 2. Renunciation by the contractor of any amount due him from the owner. This article is subject to the provisions of special laws. Art. 1893. In the cases mentioned in NOS 1 and 2 of the preceding article, the principal may furthermore bring an action against the substitute with respect to the obligations which the latter has contracted under the substitution. Art. 1608. The vendor may bring his action against every possessor whose right is derived from the vendee, even if in the second contract no mention should have been made of the right to repurchase. Without prejudice to the provisions of the mortgage law and the land registration law with respect to third persons. 4. That the favorable stipulation should not be conditioned or compensated by any kind of obligation whatever. 5. Neither of the contracting parties bears the legal representation of authorization of the third parties. If the third parties is represented, then the principles of agency apply. 6. The third person must have communicated his acceptance to the obliger before its revocation. D. Autonomy of will. Art. 1306. The contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. Three elements of a contract. A. Essential elements. Art. 1318. There is no contract unless the following requisites concur. 1. Consent of the contracting parties. 2. Object certain which is the subject matter of the contract. 3. Cause of the obligation which is established. The essential elements are those without which there can be no contract. These elements are, in turn, subdivided into common, communes, special, especials, and extraordinary. Specialissimos. The common elements are those which are present in all contracts, such as consent, object certain, and cause. The special elements are present only in certain contracts, such as delivery in real contracts or form in solemn ones. The extraordinary elements are those which are peculiar to a specific contract, i.e. price in sales. I consent. 1. Consent in general. Definition of consent. Art. 1319, first sentence. Consent is manifested by the meeting of the offer and the acceptance upon the thing and the cause which are to constitute the contract. Elements of consent. A plurality of subjects. B. Capacity. C. Intelligent and free will. D. Express or tacit manifestation of the will. E. Conformity of the internal will and its manifestation. 2. Offer. An offer is a unilateral proposition which one party makes to the other for the celebration of a contract. Art. 1321. The person making the offer may fix the time, place, and manner of acceptance, all of which must be complied with. Requisites of offer. A. Definite. The offer must be definite, so that upon acceptance, an agreement can be reached on the whole contract. Be complete. The offer must be complete, indicating with sufficient clearness the kind of contract intended and definitely stating the essential conditions of the proposed contract as well as the non-essential ones desired by the offerer. C. Intentional. An offer without seriousness, made in such manner that the other party would not fail to notice such lack of seriousness, is absolutely without juridical effects and cannot give rise to a contract, i.e. must not be made in jest, or a prank. 3. Acceptance. A requisites of acceptance. I. Unequivocal. 2. Unconditional. If the acceptance is qualified, then that is a counter-offer. Article 1319, third sentence. An amplified acceptance may or may not be an acceptance of the original offer. It depends on the circumstances. Example: A offers to sell 1,000 kilos of cement. B says he wants to buy 2,000 kilos of cement. Is the 1,000 kilos accepted? It depends. If buyer wants a block sale, that is, only 2,000 kilos and nothing less, then it is a counter-offer. B. Manifestation of acceptance. Art. 1320. An acceptance may be express or implied. Silence is ambiguous. Silence in itself is neither acceptance nor rejection. Can it mean acceptance? One must look at the circumstances. Examples: A and B are owned stalls which sell rice. C delivers 1,000 kilos of rice to A every Sunday. If A is not there, C just leaves it with A's assistant. C tries to do business with B. B is not there though. C leaves rice with B's assistant. B does not call C. Both A and B are silent. A accepted the rice because of the arrangement. If A did not want to accept the rice, then A should have called. B's silence is not acceptance. See Cognition Theory. Article 1319, second. Acceptance made by letter of telegram does not bind the offerer except from the time it came to his knowledge. This is known as the Cognition Theory. Commercial law uses the theory of manifestation. Offer and acceptance takes effect only from the time knowledge is acquired by the person to whom it is directed. If during intervening time, the offer or acceptance is extinguished by death/insanity, such offer or acceptance has no more effect. Example: Offerer gave offer on March 1st. The offer reached the offeree on March 5th. From the point of view of the offerer, offer is counted from March 5th. He can still counter MAND before March 5th. If the parties are face to face, then there is no problem since there is no time gap. The problem arises when there is a time gap. Under Article 1319, there is perfection of the contract when there is knowledge of the other party's acceptance. This has serious consequences. Example 1. The offer was made in Davao on February 1st. The offer was sent through mail which is received in Manila on February 5th. On the same day, the offer is accepted. Mail is sent to Davao on February 5th signifying acceptance. On February 8th, the party in Manila becomes insane. On February 13th, the mail reaches Davao. According to Professor Balain, under Article 1323, there is no contract since there was no contractual capacity. Example 2. The offer was made in Bacolod on March 1. It was received in Quezon City on March 3. On March 4, the offeree sends his acceptance. On March 5, the offerer countermands offer. Now, both acceptance and countermand of offer are in the mail. Whichever reaches the destination first will be counted. D. Offers through agents. Art. 1322. An offer made through an agent is accepted from the time acceptance is communicated to him. E. Effect of death, insanity. Art. 1323. An offer becomes ineffective upon the death, civil interdiction, insanity, or insolvency of either party before acceptance is conveyed. F. Withdrawal of the offer. Art. 1324. When the offerer has allowed the offeree a certain period to accept, the offer may be withdrawn at any time before acceptance by communicating such withdrawal, except when the option is founded upon consideration, something paid or promised. Article 1324 is related to Article 1479, 2. They actually say the same thing. S offers to sell a car to B for P300,000. B needs to think about it, and so B asks for 30 days and pays S P5,000. The payment of P5,000 is a distinct consideration from the price of the car. This distinct consideration of P5,000 is payment for the 30 days. B is paying for time. The option contract is separate from the contract of sale. S cannot sell the car to anybody else within that 30-day period. If S sells the car to someone else within the 30-day period, he is guilty of contractual breach. But B can buy the car before the end of the 30-day period and such will be a valid sale. S offers to sell a car to B for P300,000. B needs to think about it, and so B asks for 30 days. B does not pay S for time, but S promises to give B 30 days. In this case there is no option contract. However, in Sanchez v.S. Rigos, the Supreme Court said that even if there was no option contract, S must still communicate the withdrawal of the offer to B. If S does not communicate his withdrawal, that is tantamount to a continuing offer. Professor Balain does not agree with this. According to him, if there is no valid option contract, there should be no continuing offer. According to Professor Balain, the Supreme Court should have explained that S offers to sell a car to B for P300,000. B needs to think about it, and so B asks for 30 days and pays P5,000 to S. B decides to buy the car within 30 days. The car is not sold to anybody else. S does not want to sell the car to B. B can sue S for specific performance, compel S to sell him the car. S offers to sell a car to B for P300,000. B needs to think about it, and so B asks for 30 days and pays P5,000 to S. B decides to buy the car within 30 days. Before B is able to buy the car, S sells the car to X. B can sue S for damages. B cannot sue for specific performance since the car has been sold to an innocent purchaser. A right of first refusal is different from an option contract. A right of first refusal is the right to have first opportunity to purchase or the right to meet any other offer. On the other hand, an option contract limits the promisor's power to revoke an offer. The right of first refusal is not covered by the Civil Code. A right of first refusal is a statement by a person to another that if the former decides to sell the object, the latter will have the first offer. Here, the object is determinable. But the exercise of the right to buy is conditioned on the seller's decision to sell on terms which are not yet certain. According to Equatorial vs. Mayfair, the requirement of separate consideration is not applicable in a right of first refusal. According to Professor Balain, this is peculiar since an option contract is more firm and yet it requires the payment of separate consideration but a right of first refusal does not. However, in Litangua vs. CA, the Supreme Court said that in a right of first refusal, the consideration for the loan or mortgage is already a part of the consideration for the right of first refusal. In Ang U vs. CA, the SC said that an action for specific performance will not lie against the promisor. However, a complaint under Article 19 for damages may be filed if the actions of the promisor are whimsical. In Equatorial vs. Mayfair, the right of first refusal was violated when the vendor sold the object to another person. The SC in Equatorial vs. Mayfair said that an action for specific performance may be filed. Equatorial vs. Mayfair is totally inconsistent with ANU vs. CA. The Supreme Court has held, Equatorial vs. Mayfair, Paranaki Kings vs. CA, Latangua vs. CA, Pup vs. CA, that the right of first refusal is enforceable by an action for specific performance, and that the actual vendee may be required to sell the property to the holder of the right of first refusal at the price which he bought it. However, in a recent case, Rosen Corr vs. CA. March 8, 2001, the Supreme Court has held that the right of first refusal need not be written to be unenforceable since it is not included in the statute of frauds. Also, if the vendee is in good faith, he may not be compelled by specific performance since he relied on a title which is clean. The remedy is to go after the vendor. In a right of first refusal, there is no definite offer since the vendor has the option of deciding not to sell the object. Also, in a right of first refusal, there is no need for a separate consideration. In an option contract, there is a definite offer. According to Professor Balain, the right of first refusal is inferior to an option contract since there is no definite offer. Professor Balain does not understand why an action for specific performance is allowed in violations of rights of first refusal but not in the case of option contracts when the object is sold to another person. Why is the SC giving greater legal effect to a right of first refusal which is more tentative? Also, where the SC get these rules since the right of first refusal is not covered by the Civil Code. G. Advertisements. Art. 1325. Unless it appears otherwise, business advertisements of things for sale are not definite offers, but mere invitations to make an offer. Art. 1326. Advertisements for bidders are simply invitations to make proposals, and the advertiser is not bound to accept the highest or lowest bidder, unless the contrary appears. Most advertisements are simply invitations to make an offer and are not offers in themselves since not all the necessary terms can fit in the advertisement. Even if the ad had all the necessary terms, it's still an invitation to make offer since there is no definite person to whom the offer is being made. Public offer. H. Simulated contracts. Art. 1345. Simulation of a contract may be absolute or relative. The former takes place when the parties do not intend to be bound at all, the latter, when the parties conceal their true agreement. Art. 1346. An absolutely simulated or fictitious contract is void. A relative simulation, when it does not prejudice a third person and is not intended for any purpose contrary to law, morals, good customs, public order, or public policy, binds the parties to their real agreement. I absolutely simulated. Contratto simulado. Absolute simulation of a contract takes place when the parties do not intend to be bound at all. Article 1345. For example, X pretends to sell his car to avoid tax liability. However, X has no real intention to sell the car. An absolutely simulated or fictitious contract is void. Article 1346. 2. Relatively simulated, contratto dissimulado. Relative simulation of a contract takes place when the parties conceal their true agreement. Article 1345. In a relatively simulated contract, the parties enter into a contract but disguise it as another. For example, X has many creditors, and they are going after X's car. X cannot donate his car to Y since the creditors will just resort to acción poliana. So, X antedates a contract of sale, selling his car to Y, except that X's intention is to donate his car to Y. A relatively simulated contract, when it does not prejudice a third person and is not intended for any purpose contrary to law, morals, good customs, public order, or public policy, binds the parties to their real agreement. Article 1346. The law will apply the rules of the true contract and not the ostensible contract. 2. Object. Art. 1347 All things which are not outside the commerce of men, including future things, may be the object of a contract. All rights which are not intransmissible may also be the object of contracts. No contract may be entered into upon future inheritance except in cases expressly authorized by law. All services which are not contrary to law, morals, good customs, public order, or public policy may likewise be the object of a contract. Art. 1348 Impossible things or services cannot be the object of contracts. Art. 1349 The object of every contract must be determinate as to its kind. The fact that the quantity is not determinate shall not be an obstacle to the existence of the contract, provided it is possible to determine the same, without the need of a new contract between the parties. The object of the contract is the prestation. Thus, it is always the conduct which is to be observed. It is not a concrete object like a car. In a contract of sale, the object is the delivery of the object and not the object itself. The provisions on object, however, blur the distinction between the object of the contract, the prestation, and the object of the prestation. According to Professor Balain, these provisions are not fatal though. Requisites of object. 1. The object must be within the commerce of man, either already existing or in potency, Article 1347. Within the commerce of man means that the object is capable of appropriation and transmission. The term, in potency, means that the object will come into existence in the future. Generally in reciprocal contracts, particularly sales, the sale of future things is allowed. For example, it is possible to sell the future harvest of a farm. The coming into being of the future thing is a suspensive condition. Emptio rei sperati is a conditional sale. There is a suspensive condition. If the future thing does not come into existence, then there is no contract of sale. Emptio spei is the sale of a hope. Even if the future thing does not materialize, the buyer must pay since the buyer is taking a chance. I.e. sale of lotto ticket. Hope is a present thing. Some future things are not allowed to be objects of the prestation. The law does not allow contracts on future inheritance. 2. The object must licit, or not be contrary to law, morals, good customs, public policy, or public order, Article 1347, 3. The object must be possible, Article 1348. If the object is impossible, then the contract is void for lack of cause. Article 1348 does not talk of supervening impossibility, which is a mode of extinguishments. Impossibility under Article 1348 must be actual and contemporaneous with the making of the contract. 4. The object must be determinate as to its kind and determinable as to its quantity, Article 1349. The object need not be individualized. It must be determinate as to its kind or species. The quantity of the object may be indeterminate, so long as the right of the creditor is not rendered illusory. 5. The object must be transmissible. This is actually a redundancy, since this is already in the requisite of being within the commerce of man. 3. Cause. Art. 1350 In onerous contracts, the cause is understood to be, for each contracting party, the prestation, or promise of a thing or service by the other, in remuneratory ones, the service, or benefit which is remunerated, and in contracts of pure beneficence, the mere liberality of the benefactor. Art. 1351 The particular motives of the parties in entering into a contract are different from the cause thereof. Art. 1352 Contracts without cause, or with unlawful cause, produce no effect whatever. The cause is unlawful if it is contrary to law, morals, good customs, public order, or public policy. Art. 1353 The statement of a false cause in contracts shall render them void, if it should not be proved that they were founded upon another cause which is true and lawful. Art. 1354 Although the cause is not stated in the contract, it is presumed that it exists and is lawful, unless the debtor proves the contrary. Art. 1355 Except in cases specified by law, lesion, or inadequacy of cause shall not invalidate a contract, unless there has been fraud, mistake, or undue influence. The cause of a contract is the why of the contract, the immediate and most proximate purpose of the contract, the essential reason which impels the contracting parties to enter into it and which explains and justifies the creation of the obligation through such contract. The cause is different from consideration. Consideration in the Anglo-American sense must always be valuable or capable of pecuniary estimation. Cause, on the other hand, need not be material at all, and may consist in a moral satisfaction for the promisor. Requisites of cause 1. It must exist 2. It must be true 3. It must be licit. Cause is different from motive. Cause is the proximate why while motive is the ultimate why. For example, A wants to sell his house for P60M because A is moving to Canada. B is willing to buy the house for P60M. In this case, the cause for A is the P60M while the cause for B is the house. A's motive is to dispose of the house which he does not need since A is going to Canada. Like failure of or lack of object, the failure of cause has an effect on the contract. If there is no cause or the cause is illegal, then the contract is void. This is unlike the lack of consent. When consent is lacking, the contract is not void. The contract is merely voidable. General rule: failure of motive as a general rule does not affect the contract. Exception: motive affects the contract when 1. The motive becomes a suspensive condition, or 2. The realization of the motive is the cause for the contract and there is an intervening serious mistake of fact. In onerous contracts, the cause is the prestation or promise of a thing or service by the other party. It has been held that, as a mortgage is an accessory contract, its cause, or consideration is the very cause or consideration of the principal contract, from which it receives its life, and without which it cannot exist as an independent contract. China Bank vs. Licaco. In remuneratory contracts, the cause is the service or benefit which is remunerated. A remuneratory contract is one where a party gives something to another because of some service or benefit given or rendered by the latter to the former, where such service or benefit was not due as a legal obligation. In gratuitous contracts, the cause is the mere liberality of the benefactor. Delivery, for real contracts. Form, for formal contracts. Be natural elements. The natural elements are those which are derived from the nature of the contract and ordinarily accompany the same. They are presumed by law, although they can be excluded by the contracting parties if they so desire. I write to resolve, Article 1191, 2. Warranties in sales contracts. See accidental elements. The accidental elements are those which exist only when the parties expressly provide for them for the purpose of limiting or modifying the normal effects of the contract, i.e. conditions, terms, modes. 4. Stages of a contract. A. Preparation, conception, or generation, which is the period of negotiation and bargaining, ending at the moment of agreement of the parties. B. Perfection or birth of the contract, which is the moment when the parties come to agree on the terms of the contract. General rule: contracts are perfected by mere consent. The principle of consensuality, Article 1315. Exception: real contracts, such as deposit, pledge, and comodatum, are not perfected until the delivery of the object of the obligation, Article 1316. C. Consummation or death, which is the fulfillment or performance of the terms agreed upon. 5. Classification of contracts. A. According to degree of dependence. I. Preparatory. A preparatory contract is one which has for its object the establishment of a condition in law which is necessary as a preliminary step towards the celebration of another subsequent contract, i.e. partnership, agency. 2. Principal. A principal contract is one which can subsist independently from other contracts and whose purpose can be fulfilled by themselves, i.e. sales, lease. 3. Accessory. An accessory contract is one which can exist only as a consequence of, or in relation with, another prior contract, i.e. pledge, mortgage. B. According to perfection I consensual. A consensual contract is one which is perfected by mere agreement of the parties, i.e. sales, lease. 2. Real. A real contract is one which requires not only the consent of the parties for their perfection, but also the delivery of the object by one party to the other, i.e. comodatum, deposit, pledge. C. According to their form I common or informal. An informal contract is one which does not require some particular form, i.e. loan, lease. 2. Special or formal. A formal contract is one which requires some particular form, i.e. donation, chattel mortgage. D. According to purpose. I. Transfer of ownership, i.e. sale. 2. Conveyance of use, i.e. comodatum. 3. Rendition of service, i.e. agency. E. According to subject matter I. Things, i.e. sale, deposit, pledge. 2. Services, i.e. agency, lease of services. F. According to the nature of the obligation I. Bilateral. A bilateral contract is one which gives rise to reciprocal obligations for both parties, i.e. sale, lease. 2. Unilateral. A unilateral contract is one which gives rise to an obligation for only one of the parties, i.e. comodatum, gratuitous deposit. G. According to quasi-onerous. An onerous contract is one in which each of the parties aspires to procure for himself a benefit through the giving of an equivalent or compensation, i.e. sale. 2. Gratuitous. A gratuitous contract is one in which one of the parties proposes to give to the other a benefit without any equivalent or compensation, i.e. comodatum. H. According to risk I. Commutative. A commutative contract is one in which each of the parties acquires an equivalent of his prestation and such equivalent is pecuniarily appreciable and already determined from the moment of the celebration of the contract, i.e. lease. 2. Aleatory. An aleatory contract is one in which each of the parties has to his account the acquisition of an equivalent prestation, but such equivalent, although pecuniarily appreciable, is not yet determined, at the moment of the celebration of the contract. Since it depends upon the happening of an uncertain event, thus charging the parties with the risk of loss or gain, i.e. insurance. I. According to name I. Nominate. A nominate contract is one which has a name and is regulated by special provisions of law, i.e. sale, lease. 2. Innominate. Art. 1307 Innominate contracts shall be regulated by the stipulations of the parties, by the provisions of Titles I and II of this book, by the rules governing the most analogous nominate contracts, and by the customs of the place. An innominate contract is one that does not have a name and is not regulated by special provisions of law. A contract is not void just because it has no name. It is not a requisite for validity. A contract may have no name but it can be valid provided it has all the elements of a contract and all the restrictions are respected. 4 classes of innominate contracts. Do ut, I give that you give. Do ut facius, I give that you do. Facio ut, I do that you give. Facio ut facius, I do that you do. B. Form of contracts. Art. 1356 contracts shall be obligatory, in whatever form they may have been entered into, provided all the essential requisites for their validity are present. However, when the law requires that a contract be in some form in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requirement is absolute and indispensable. In such cases, the right of the parties stated in the following article cannot be exercised. Art. 1357 If the law requires a document or other special form, as in the acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form, once the contract has been perfected. This right may be exercised simultaneously with the action upon the contract. Art. 1358 The following must appear in a public document. 1. acts and contracts which have for their object the creation, transmission, modification, or extinguishment of real rights over immovable property, sales of real property or of an interest therein governed by Articles 1403, Number 2, and 1405. 2. The cession, repudiation, or renunciation of hereditary rights or of those of the conjugal partnership of gains. 3. The power to administer property, or any other power which has for its object an act appearing or which should appear in a public document, or should prejudice a third person. 4. The cession of actions or rights proceeding from an act appearing in a public document. All other contracts where the amount involved exceeds 500 pesos must appear in writing, even a private one. But sales of goods, chattels, or things in action are governed by Articles 1403, Number 2 and 1405. General rule: there is no need for a specific form, but there must still be some manifestation of consent. Exception: when the written form is required. 1. For validity. If it not written, the same is void. Examples are donations, Articles 748, 749, Anticrisis, Article 2134, Interest in a loan, Article 1956, Sale of land by an agent. Article 1874, Contribution of immovables in a partnership, Article 1773. 2. For enforceability. The contract is unenforceable if it is not written. A. An agreement that by its terms is not to be performed within a year from the making thereof, Article 1403, a. B. A special promise to answer for the debt, default, or miscarriage of another, Article 1403, b. C. An agreement made in consideration of marriage, other than a mutual promise to marry. Article 1403, c. D. An agreement for the sale of goods, chattels, or things in action, at a price not less than P500, unless the buyer accepts and receives part of such goods and chattels, or the evidence, or some of them, of such things in action, or pay at the time some part of the purchase money. But when a sale is made by auction and entry is made by the auctioneer in his sales book, at the time of sale, of the amount and kind of property sold, terms of sale, price, names of the purchasers and person on whose account the sale is made, it is a sufficient memorandum, Article 1403, d. E. An agreement of lease for a period of more than 1 year, or the sale of real property or of an interest therein, Article 1403, e. F. A representation as to the credit of a third person, Article 1403, f. G. No express trusts concerning an immovable or any interest therein may be proved by parole evidence, Article 1443. 3. For registrability. The following must appear in a public instrument. A. Acts and contracts which have for their object the creation, transmission, modification, or extinguishment of real rights over immovable property, sales of real property or of an interest therein governed by Articles 1403, 2, and 1405. B. The cession, repudiation, or renunciation of hereditary rights or of those of the conjugal partnership of gains. C. The power to administer property, or any other power which has for its object an act appearing or which should appear in a public document, or should prejudice a third person. D. The cession of actions or rights proceeding from an act appearing in a public document. Contracts enumerated in Article 1358 are valid as between the contracting parties even when they have not been reduced to public or private writings. Except in certain cases where public instruments and registration are required for the validity of the contract itself. The legalization of a contract by means of a public writing and its entry in the register are not essential solemnities or requisites for the validity of the contract as between the contracting parties, but are required for the purposes of making it effective as against third person. Article 1357 gives the contracting parties the coercive power to reciprocally compel the execution of the formalities required by law, as soon as the requisites for the validity of the contracts are present. See Reformation of Instruments. Art. 1359. When, there having been a meeting of the minds of the parties to a contract, their true intention is not expressed in the instrument purporting to embody the agreement, by reason of mistake, fraud, inequitable conduct, or accident. One of the parties may ask for the reformation of the instrument to the end that such true intention may be expressed. If mistake, fraud, inequitable conduct, or accident has prevented a meeting of the minds of the parties, the proper remedy is not reformation of the instrument but annulment of the contract. Art. 1360. The principles of the general law on the reformation of instruments are hereby adopted insofar as they are not in conflict with the provisions of this code. Art. 1361. When a mutual mistake of the parties causes the failure of the instrument to disclose their real agreement, said instrument may be reformed. Art. 1362. If one party was mistaken and the other acted fraudulently or inequitably in such a way that the instrument does not show their true intention, the former may ask for the reformation of the instrument. Art. 1363. When one party was mistaken and the other knew or believed that the instrument did not state their real agreement, but concealed that fact from the former, the instrument may be reformed. Art. 1364. When through the ignorance, lack of skill, negligence or bad faith on the part of the person drafting the instrument or of the clerk or typist, the instrument does not express the true intention of the parties, the courts may order that the instrument be reformed. Art. 1365. If two parties agree upon the mortgage or pledge of real or personal property, but the instrument states that the property is sold absolutely or with a right of repurchase, reformation of the instrument is proper. Art. 1366. There shall be no reformation in the following cases. 1. Simple donations inter vivos wherein no condition is imposed. 2. Wills. 3. When the real agreement is void. Art. 1367. When one of the parties has brought an action to enforce the instrument, he cannot subsequently ask for its reformation. Art. 1368. Reformation may be ordered at the instance of either party or his successors in interest, if the mistake was mutual, otherwise, upon petition of the injured party, or his heirs and assigns. Art. 1369. The procedure for the reformation of instruments shall be governed by rules of court to be promulgated by the Supreme Court. Once the minds of the contracting parties meet, a valid contract exists, whether the agreement is reduced to writing or not. There are instances, however, where in reducing their agreements to writing, the true intention of the contracting parties are not correctly expressed in the document, either by reason of mistake, fraud, inequitable conduct, or accident. It is in such cases that reformation of instruments is proper. The action for such relief rests on the theory that the parties came to an understanding, but in reducing it to writing, through mutual mistake, fraud, or some other reason, some provision was omitted or mistakenly inserted. And the action to change the instrument so as to make it conform to the contract agreed upon. Reformation distinguished from annulment. The action for reformation of instruments presupposes that there is a valid existing contract between the parties, and only the document or instrument which was drawn up and signed by them does not correctly express the terms of their agreement. On the other hand, if the minds of the parties did not meet, or if the consent of either one was vitiated by violence or intimidation or mistake or fraud, so that no real and valid contract was made, the action is for annulment. Annulment involves a complete nullification of the contract, while reformation gives life to it upon certain corrections. Operation and effect of reformation. Upon reformation of an instrument, the general rule is that it relates back to, and takes effect from the time of its original execution, especially as between the parties. Requisites of reformation. 1. There must have been a meeting of the minds upon the contract. 2. The instrument or document evidencing the contract does not express the true agreement between the parties. 3. The failure of the instrument to express the agreement must be due to mistake, fraud, inequitable conduct or accident. Requisites of mistake: A. That the mistake is one of fact. Whenever an instrument is drawn with the intention of carrying an agreement previously made, but which, due to mistake or inadvertence of the draftsman or clerk, does not carry out the intention of the parties, but violates it, there is a ground to correct the mistake by reforming the instrument. B. That it was common to both parties. A written instrument may be reformed where there is a mistake on one side and fraud or inequitable conduct on the other, as where one party to an instrument has made a mistake and the other knows it and conceals the truth from him. The mistake of one party must refer to the contents of the instrument and not the subject matter or the principal conditions of the agreement. In the latter case, an action for annulment is the proper remedy. If two parties agree upon the mortgage or pledge of real property or personal property, but the instrument states that the property is sold absolutely or with a right of repurchase, reformation is proper. C. The proof of mutual mistake must be clear and convincing. Limitations of reformation. 1. Reformation is not proper in the following cases. A simple donations inter vivos wherein no condition is imposed. B. Wills. C. When the real agreement is void. 2. Who may ask for reformation? A. If the mistake is mutual. Reformation may be ordered at the instance of either party or his successors in interest. B. If the mistake is not mutual. Reformation may be ordered upon petition of the injured party or his heirs and assigns. 3. Effect of enforcing an action. When one of the parties has brought an action to enforce the instrument, he cannot subsequently ask for its reformation. D. Interpretation of contracts. Where the parties have reduced their contract into writing, the contents of the writing constitutes the sole repository of the terms of the agreement between the parties. Whatever is not found in the writing must be understood as waived and abandoned. Generally, therefore, there can be no evidence of the terms of the contract other than the contents of the writing, unless it is alleged and proved that the intention of the parties is otherwise. Art. 1370. If the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulations shall control. If the words appear to be contrary to the evident intention of the parties, the latter shall prevail over the former. When the terms of the agreement are so clear and explicit that they do not justify an attempt to read into it any alleged intention of the parties, the terms are to be understood literally just as they appear on the face of the contract. When the true intent and agreement of the parties is established, it must be given effect and prevail over the bare words of the written agreement. Art. 1371. In order to judge the intention of the contracting parties, their contemporaneous and subsequent acts shall be principally considered. Art. 1372. However general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intended to agree. Art. 1373. If some stipulation of any contract should admit of several meanings, it shall be understood as bearing that import which is most adequate to render it effectual. Art. 1374. The various stipulations of a contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. Where the instrument is susceptible of two interpretations, one which will make it invalid and illegal, and another which will make it valid and legal, the latter interpretation should be adopted. In the construction of an instrument where there are several provisions or particulars, such a construction is, if possible, to be adopted as will give effect to all. Art. 1375. Words which may have different significations shall be understood in that which is most in keeping with the nature and object of the contract. Art. 1376. The usage or custom of the place shall be borne in mind in the interpretation of the ambiguities of a contract, and shall fill the omission of stipulations which are ordinarily established. When there is doubt as to the meaning of any particular language, it should be determined by a consideration of the general scope and purpose of the instrument in which it occurs. An instrument may be construed according to usage in order to determine its true character. Art. 1377. The interpretation of obscure words or stipulations in a contract shall not favor the party who caused the obscurity. The party who draws up a contract in which obscure terms or clauses appear, is the one responsible for the obscurity or ambiguity, they must therefore be construed against him. Art. 1378. When it is absolutely impossible to settle doubts by the rules established in the preceding articles, and the doubts refer to incidental circumstances of a gratuitous contract, the least transmission of rights and interests shall prevail. If the contract is onerous, the doubt shall be settled in favor of the greatest reciprocity of interests. If the doubts are cast upon the principal object of the contract in such a way that it cannot be known what may have been the intention or will of the parties, the contract shall be null and void. Art. 1379. The principles of interpretation stated in Rule 123 of the Rules of Court shall likewise be observed in the construction of contracts. Rule 130, Rules of Court. Sector 10. Interpretation of a writing according to its legal meaning. The language of a writing is to be interpreted according to the legal meaning it bears in the place of its execution, unless the parties intended otherwise. Sector 11. Instrument construed so as to give effect to all provisions. In the construction of an instrument where there are several provisions or particulars, such a construction is, if possible, to be adopted as will give effect to all. Sector 12. Interpretation according to intention, general and particular provisions. In the construction of an instrument, the intention of the parties is to be pursued, and when a general and a particular provision are inconsistent, the latter is paramount to the former. So a particular intent will control a general one that is inconsistent with it. When a general and a particular provision are inconsistent, the particular provision will control. Sector 13. Interpretation according to circumstances. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject thereof and of the parties to it, may be shown, so that the judge may be placed in the position of those whose language he is to interpret. Sector 14. Peculiar signification of terms. The terms of a writing are presumed to have been used in their primary and general acceptation, but evidence. Now, Rule 130, 10-19. Is admissible to show that they have a local, technical, or otherwise peculiar signification, and were so used and understood in the particular instance, in which case the agreement must be construed accordingly. Sector 15. Written words control printed. When an instrument consists partly of written words and partly of a printed form, and the two are inconsistent, the former controls the latter. Sector 16. Experts and interpreters to be used in explaining certain writings. When the characters in which an instrument is written are difficult to be deciphered, or the language is not understood by the court, the evidence of persons skilled in deciphering the characters, or who understand the language, is admissible to declare the characters or the meaning of the language. Sector 17. Of two constructions, which preferred. When the terms of an agreement have been intended in a different sense by the different parties to it, that sense is to prevail against either party in which he supposed the other understood it, and when different constructions of a provision are otherwise equally proper, that is to be taken which is the most favorable to the party in whose favor the provision was made. Sector 18. Construction in favor of natural right. When an instrument is equally susceptible of two interpretations, one is favor of natural right and the other against it, the former is to be adopted. Sector 19. Interpretation according to usage. An instrument may be construed according to usage, in order to determine its true character. Defective contracts. The remaining chapters deal with defective contracts. The Civil Code made major and important improvements on this topic. Unlike the Spanish Code, the defective contracts were ambiguous and had unclear classifications. They were simply void or voidable. Here, in our present code, there are 4 types of defective contracts, from the serious to less serious, in the following order. However, our code still has some imperfections. As pointed out by Tolentino, there must be a relatively void contract. For example, in an assignment of lease without authority, this is void as to third parties, but valid as between the parties. There have been several cases decided by our Supreme Court wherein a chattel mortgage over real property was declared void as to third parties but valid as between the parties. Whatever imperfections the code has, it still is better than other codes on this topic. 1. Rescissible contracts. Void. Rescissible. Unenforceable. Voidable. Art. 1,380 contracts validly agreed upon may be rescinded in the cases established by law. Art. 1,381 The following contracts are rescissible. 1. Those which are entered into by guardians whenever the wards whom they represent suffer lesion by more than 1/4 of the value of the things which are the object thereof. 2. Those agreed upon in representation of absentees, if the latter suffer the lesion stated in the preceding number. 3. Those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due them. 4. Those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. 5. All other contracts specially declared by law to be subject to rescission. Art. 1,382 Payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were effected, are also rescissible. Art. 1,383 The action for rescission is subsidiary, it cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same. Art. 1,384 Rescission shall be only to the extent necessary to cover the damages caused. Art. 1,385 Rescission creates the obligation to return the things which were the object of the contract, together with their fruits, and the price with its interest. Consequently, it can be carried out only when he who demands rescission can return whatever he may be obliged to restore. Neither shall rescission take place when the things which are the object of the contract are legally in the possession of third persons who did not act in bad faith. In this case, indemnity for damages may be demanded from the person causing the loss. Art. 1,386 Rescission referred to in NOS 1 and 2 of Article 1381 shall not take place with respect to contracts approved by the courts. Art. 1,387 All contracts by virtue of which the debtor alienates property by gratuitous title are presumed to have been entered into in fraud of creditors, when the donor did not reserve sufficient property to pay all debts contracted before the donation. Alienations by onerous title are also presumed fraudulent when made by persons against whom some judgment has been issued. The decision or attachment need not refer to the property alienated, and need not have been obtained by the party seeking the rescission. In addition to these presumptions, the design to defraud creditors may be proved in any other manner recognized by the law of evidence. Art. 1,388 Whoever acquires in bad faith the things alienated in fraud of creditors, shall indemnify the latter for damages suffered by them on account of the alienation, whenever, due to any cause, it should be impossible for him to return them. If there are two or more alienations, the first acquirer shall be liable first, and so on successively. Art. 1,389 The action to claim rescission must be commenced within 4 years. For persons under guardianship and for absentees, the period of 4 years shall not begin until the termination of the former's incapacity, or until the domicile of the latter is known. This is not be to confused with resolution, discussed in Article 1191. This chapter on rescissible contracts is the proper rescissible. According to Savola, rescission is a process designated to render inefficacious a contract validly entered into and normally binding, by reason of external conditions, causing an economic prejudice to a party or to his creditors. A rescissible contract is a contract which is valid because it contains all the essential requisites prescribed by law, but which is defective because of injury or damage to either of the contracting parties or to third persons. As a consequence of which it may be rescinded by means of a proper action for rescission. Rescission is a remedy granted by law to the contracting parties, and even to third persons, to secure the reparation of damages caused to them by a contract, even if the same should be valid, by means of the restoration of things to their condition prior to the celebration of the contract. Requisites of rescission. The contract must be a rescissible contract under Article 1381 or Article 1382. The following contracts are rescissible. Those entered into by guardians whenever the whom they represent suffer lesion by more than 1/4 of the value of things which are the object thereof, Article 1381, 1. Rescission shall not take place with respect to contracts approved by the court, Article 1386. As a rule, when a guardian enters into a contract involving the disposition of the ward's property, the guardian must secure the approval of the guardianship court. A guardian is only authorized to manage the estate of the ward. A guardian has no power to dispose of any portion of the estate without approval of the court. If more than acts of mere administration are involved, judicial approval is necessary. In case of sale, mortgage, or other encumbrance of any portion of the estate which does not have judicial approval is an unenforceable contract, Article 1403, 1. Therefore, Article 1381, 1, is limited to contracts which constitute mere acts of administration, i.e. the purchase of equipment for the cultivation of lands, purchase of materials for repair of buildings, etc. Lesion is very difficult to apply in practice. For example, A is the agent of B. B owns land worth P10M. A sells the land for P7M. From the facts, the lesion suffered by B is 30%. In practice, are you sure that P10M is the fair market value of the land? What if the situation is urgent and that property must be disposed of right away? Another example, A is the agent of B. B owns land worth P10M. C wants to buy the land. C is willing to pay P7M, lump sum payment. D is willing to pay P10M but on installments. To those agreed upon in representation of absentees, if the absentee suffers lesion by more than 1/4 of the value of things which are the object thereof, Article 1381, 2. Rescission shall not take place with respect to contracts approved by the court, Article 1386. As a rule, when the legal representative of an absentee enters into a contract involving the disposition of the absentee's property, he must secure the approval of the court. A legal representative is only authorized to manage the estate of the absentee. He has no power to dispose of any portion of the estate without approval of the court. If more than acts of mere administration are involved, judicial approval is necessary. In case of sale, mortgage, or other encumbrance of any portion of the estate which does not have judicial approval is an unenforceable contract, Article 1403, 1. Therefore, Article 1381, 2, is limited to contracts which constitute mere acts of administration, i.e. the purchase of equipment for the cultivation of lands, purchase of materials for repair of buildings, etc. Lesion is very difficult to apply in practice. For example, A is the agent of B. B owns land worth P10M. A sells the land for P7M. From the facts, the lesion suffered by B is 30%. In practice, are you sure that P10M is the fair market value of the land? What if the situation is urgent and that property must be disposed of right away? Another example, A is the agent of B. B owns land worth P10M. C wants to buy the land. C is willing to pay P7M, lump sum payment. D is willing to pay P10M but on installments. 3. Those undertaken in fraud of creditors when the creditors cannot in any other manner collect the claims due them. Article 1381, 3. This is an exception to the principle of relativity of contracts. Creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them, Article 1177. Creditors are protected in cases of contracts intended to defraud them, Article 1313. In determining whether or not a certain conveyance is fraudulent, the question in every case is whether the conveyance was a bona fide transaction or trick and contrivance to defeat creditors, or whether it conserves to the debtor a special right. All contracts by virtue of which the debtor alienates property by gratuitous tile are presumed to have been entered into in order to defraud creditors, when the donor did not reserve sufficient property to pay all debts contracted before the donation. Article 1387, first. Alienations by onerous title are also presumed fraudulent when made by persons against whom some judgment has been rendered in any instance or some writ of attachment has been issued. The decision or attachment need not refer to the property alienated, and need not have been obtained by the party seeking the rescission. Article 1387, second. Badges of fraud. 1. The fact that the consideration of the conveyance is inadequate. 2. A transfer made by a debtor after suit has begun and while it is pending against him. 3. A sale upon credit by an insolvent debtor. 4. Evidence of large indebtedness or complete insolvency. 5. The transfer of all or nearly all of his property by a debtor, especially when he is insolvent or greatly embarrassed financially. 6. The fact that the transfer is made between father and son when there are present any of the above circumstances. 7. The failure of the vendee to take exclusive possession of all the property. For those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. Article 1381, 4. Article 1381, 4, refers to a contract executed by the defendant in a suit involving the ownership or possession of a thing, when such contract is made without the knowledge and approval of the plaintiff or court. As in the case of a contract in fraud of creditors, the remedy of rescission in this case is given to a third person who is not a party to the contract. The purpose is to protect the plaintiff. V. All other contracts specially declared by law to be the subject of rescission. Article 1381, 5. The following provision in sales are examples of rescissible contracts declared by law. Arts 1526, 1534, 1538, 1539, 1540, 1556, 1560, 1567, 1659. Payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were effected. Article 1382, b. The person asking for rescission must have no other legal means to obtain reparation for the damages suffered by him. Article 1383, c. The person demanding rescission must be able to return whatever he may be obliged to restore if rescission is granted. Article 1385, first par. This requisite is only applicable if the one who suffers the lesion is a party to the contract. This requisite does not apply when a defrauded creditor resorts to acción pauliana. D. The things which are the object of the contract must not have passed legally to the possession of a third person acting in good faith. Article 1385, second. Whoever acquires in bad faith the things alienated in fraud of creditors, shall indemnify the latter for damages suffered by them on account of the alienation, whenever, due to any cause, it should be impossible for him to return them. Article 1388, 1 St. If there are two or more alienations, the first acquirer shall be liable first, and so on successively. Article 1388, second. The action for rescission must be brought within the prescriptive period of 4 years. Article 1389, 2. Voidable contracts. Art. 1390. The following contracts are voidable or annullable, even though there may have been no damage to the contracting parties. 1. Those where one of the parties is incapable of giving consent to a contract. 2. Those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. These contracts are binding, unless they are annulled by a proper action in court. They are susceptible of ratification. Art. 1391. The action for annulment shall be brought within 4 years. This period shall begin. In cases of intimidation, violence, or undue influence, from the time the defect of the consent ceases. In case of mistake or fraud, from the time of the discovery of the same. And when the action refers to contracts entered into by minors or other incapacitated persons, from the time the guardianship ceases. Art. 1392 Ratification extinguishes the action to annul avoidable contract. Art. 1393 Ratification may be effected expressly or tacitly. It is understood that there is a tacit ratification if, with knowledge of the reason which renders the contract voidable and such reason having ceased, the person who has a right to invoke it should execute an act which necessarily implies an intention to waive his right. Art. 1394 Ratification may be effected by the guardian of the incapacitated person. Art. 1395 Ratification does not require the conformity of the contracting party who has no right to bring the action for annulment. Art. 1396 Ratification cleanses the contract from all its defects from the moment it was constituted. Art. 1397 The action for the annulment of contracts may be instituted by all who are thereby obliged principally or subsidiarily. However, persons who are capable cannot allege the incapacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employed fraud, or caused mistake base their action upon these flaws of the contract. Art. 1398 An obligation having been annulled, the contracting parties shall restore to each other the things which have been the subject matter of the contract, with their fruits, and the price with its interest, except in cases provided by law. In obligations to render service, the value thereof shall be the basis for damages. Art. 1399 When the defect of the contract consists in the incapacity of one of the parties, the incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or price received by him. Art. 1400 Whenever the person obliged by the decree of annulment to return the thing cannot do so because it has been lost through his fault, he shall return the fruits received and the value of the thing at the time of the loss, with interest from the same date. Art. 1401 The action for annulment of contracts shall be extinguished when the thing which is the object thereof is lost through the fraud or fault of the person who has a right to institute the proceedings. If the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action, unless said loss took place through the fraud or fault of the plaintiff. Art. 1402 As long as one of the contracting parties does not restore what in virtue of the decree of annulment he is bound to return, the other cannot be compelled to comply with what is incumbent upon him. Avoidable contract is a contract in which all of the essential elements for validity are present, but the element of consent is vitiated either by lack of legal capacity of one of the contracting parties or by mistake, violence, intimidation, undue influence, or fraud. Voidable contracts are binding unless they are annulled by a proper action court. They are susceptible to confirmation. There is a difference between confirmation and ratification. Confirmation is the process of curing the defect of a voidable contract. Ratification is the process of curing contracts which are defective because they were entered into without authority. The following contracts are voidable or annullable, even though there may have been no damage to the contracting parties. Those where one of the parties is incapable of giving consent to a contract. The following cannot give consent to a contract, Article 1327. Unemancipated minors. Where necessaries are sold and delivered to a minor or other person without capacity to act, he must pay a reasonable price therefor. Necessaries include everything that is indispensable for sustenance, dwelling, clothing, and medical attendance. Contracts effected by minors who have already passed the age of puberty and adolescence and are near the adult age, when they pretend to have already reached the age of majority, while in fact they have not, are valid. Cannot be permitted afterwards to excuse themselves from compliance with obligations assumed by them or seek their annulment. This is in consonance with the rules of estoppel. Mercado vs Espiritu. However, in Braganza v. Davila, the SC said that the misrepresentation of an incapacitate person does not stop him from denying that he was of age, or from asserting that he was underage, at the time he entered into the contract. According to Professor Balain, this view is very logical. If the minor is too young to enter into contracts, he is too young to be stopped. Two insane or demented persons, and deaf mutes who do not know how to write. Art. 1328 contracts entered into during a lucid interval are valid. Contracts agreed to in a state of drunkenness or during a hypnotic spell are voidable. Art. 1329 The incapacity declared in Article 1327 is subject to the modifications determined by law, and is understood to be without prejudice to special disqualifications established in the laws. Be those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. Art. 1330 A contract where consent is given through mistake, violence, intimidation, undue influence, or fraud is voidable. I mistake. Art. 1331 In order that mistake may invalidate consent, it should refer to the substance of the thing which is the object of the contract, or to those conditions which have principally moved one or both parties to enter into the contract. Mistake as to the identity or qualification of one of the parties will vitiate consent only when such identity or qualifications have been the principal cause of the contract. A simple mistake of account shall give rise to its correction. Art. 1332 When one of the parties is unable to read, or if the contract is in a language not understood by him, and mistake or fraud is alleged, the person enforcing the contract must show that the terms thereof have been fully explained to the former. Art. 1333 There is no mistake if the party alleging it knew the doubt, contingency, or risk affecting the object of the contract. Art. 1334 Mutual error as to the legal effect of an agreement when the real purpose of the parties is frustrated, may vitiate consent. Art. 1342 Misrepresentation by a third person does not vitiate consent, unless such misrepresentation has created substantial mistake and the same is mutual. Art. 1343 Misrepresentation made in good faith is not fraudulent but may constitute error. 2. Violence. Art. 1335, First. There is violence when in order to wrest consent, serious or irresistible force is employed. Violence shall annul the obligation, although it may have been employed by a third person who did not take part in the contract, Article 1336. Requisites of violence. 1. Irresistible physical force is employed. 2. The force is the determining cause for giving consent. 3. Intimidation. Art. 1335, Second. There is intimidation when one of the contracting parties is compelled by a reasonable and well-grounded fear of an imminent and grave evil upon his person or property, or upon the person or property of his spouse, descendants, or ascendants, to give his consent. Requisites of intimidation. 1. The threat must be the determining cause for giving consent. 2. The threatened act is unjust and unlawful. A threat to enforce one's claim through competent authority, if the claim is just or legal, does not vitiate consent, Article 1335, Fourth. The threat to enforce a right should not be aimed at a result which is contrary to law or morals, or which is unjust and contrary to good faith. Although it is lawful to exercise rights, it is not always lawful to use them for purposes different from those for which they were created. Thus, although it is lawful to report crimes, the threat to report it may be illicit if the purpose is not to cooperate in the discovery and prosecution of the crime, but to obtain some prestation from the culprit which otherwise could not be obtained and which does not constitute indemnity for damages for the crime committed. Thus, the rule is, generally, a threat to do something lawful does not constitute intimidation. Example: if you don't marry my daughter, I'll report you to the IBP. This is not unlawful because the person did commit immorality. Sometimes, though it may constitute intimidation. Example, A saw B commit murder. A threatened B that he will report him to the police unless B gives A his house. This is intimidation because there is no connection between the crime and the contract. 3. The threat is real and serious. For example, the threat must be to kill you or burn your house and not merely to pinch you. 4. The threat produces a well-grounded fear that the person making it can and will inflict harm. To determine the degree of intimidation, the age, sex, and condition of the person shall be borne in mind. Article 1335, 3rd. For example, a 75-year-old man who is bedridden and says that he will kill you does not produce a well-grounded fear. Intimidation shall annul the obligation, although it may have been employed by a third person who did not take part in the contract. Article 1336. For undue influence. Art. 1337. There is undue influence when a person takes improper advantage of his power over the will of another, depriving the latter of a reasonable freedom of choice. The following circumstances shall be considered: the confidentiality, family, spiritual and other relations between the parties, or the fact that the person alleged to have been unduly influenced was suffering from mental weakness, or was ignorant or in financial distress. V. Fraud. Art. 1332. When one of the parties is unable to read, or if the contract is in a language not understood by him, and mistake or fraud is alleged, the person enforcing the contract must show that the terms thereof have been fully explained to the former. Art. 1338. There is fraud when, through insidious words or machinations of one of the contracting parties, the other is induced to enter into a contract which, without them, he would not have agreed to. This is known as deceit or dolo causanti. This is different from dolo incident, which means fraud on things which would not prevent you from entering into a contract but may hold the other liable for damages. Requisites of fraud. One fraud is employed by one party on the other. Articles 1342, 1344. 2. The other party was induced to enter into the contract. Article 1338. 3. The fraud must be serious. Article 1344, 4. There is damage or injury caused. Art. 1339. Failure to disclose facts, when there is a duty to reveal them, as when the parties are bound by confidential relations, constitutes fraud. Art. 1340. The usual exaggerations in trade, when the other party had an opportunity to know the facts, are not in themselves fraudulent. Art. 1341. A mere expression of an opinion does not signify fraud, unless made by an expert and the other party has relied on the former's special knowledge. Art. 1342. Misrepresentation by a third person does not vitiate consent, unless such misrepresentation has created substantial mistake and the same is mutual. Art. 1343. Misrepresentation made in good faith is not fraudulent but may constitute error. Art. 1344. In order that fraud may make a contract voidable, it should be serious and should not have been employed by both contracting parties. Incidental fraud only obliges the person employing it to pay damages. If a third person should commit violence or intimidation on one of the contracting parties and this vitiates the contracting party's consent, then the contract may be annulled. Article 1336. By analogy, if a third person should exert undue influence on one of the contracting parties and this vitiates the consent of the contracting party, then the contract may be annulled. However, if the third party commits fraud, damages is the only remedy unless the fraud committed by the third person has created a mutual substantial mistake. Article 1342. Rules regarding voidable contracts. A. Voidable contracts are effective unless set aside. Article 1390. B. The validity of a voidable contract can only be assailed in a suit for that purpose, i.e. complaint or counterclaim. The action for annulment of contracts may be instituted by all who are thereby obliged principally or subsidiarily. However, persons who are capable cannot allege the incapacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employed fraud, or caused mistake base their action upon these flaws of the contract. Article 1397. The action for annulment shall be brought within 4 years. This period shall begin I. Intimidation, from the time the defect of the consent ceases. 2. Violence, from the time the defect of the consent ceases. 3. Undue influence, from the time the defect of the consent ceases. 4. Mistake, from the time of the discovery of the mistake. v. Fraud, from the time of the discovery of the fraud. The 4-year prescription period to annul contracts entered into by minors or other incapacitated persons shall begin from the time the guardianship ceases. Article 1391, 4th. An obligation having been annulled, the contracting parties shall restore to each other the things which have been the subject matter of the contract, with their fruits, and the price with its interest, except in cases provided by law. Article 1398, 1st. In obligations to render service, the value thereof shall be the basis for damages. Article 1398, 2nd. When the defect of the contract consists in the incapacity of one of the parties, the incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or price received by him. Article 1399. What if the thing to be returned is lost? Lost due to fault of defendant. Defendant has to pay the plaintiff 1. Value of the thing lost. 2. Fruits if any. 3. Interest. 2. Loss due to a fortuitous event or due to a third party. Defendant has to pay the plaintiff 1. Value of the thing lost. 2. Fruits if any. 3. Loss due to fault or fraud of plaintiff. The plaintiff loses the right to annul. Article 1401. There is fault on the part of the plaintiff once the plaintiff regains capacity. For loss without fault on the plaintiff's part. Commentators have a difference of opinion. 1. The right to annul is extinguished unless the plaintiff offers to pay the value of the object at the time of loss. 2. The plaintiff is entitled to annul without having to pay anything. As long as one of the contracting parties does not restore what in virtue of the decree of annulment he is bound to return, the other cannot be compelled to comply with what is incumbent upon him. Article 1402. The action for annulment will not prosper in the following. I. If the contract has been confirmed. Article 1392, 2. If the action to annul has prescribed. Article 1391. 3. When the thing which is the object of the contract is lost through the fault or fraud of the person who has a right to institute the proceedings. Article 1401, 1st. 4. Estoppel. C. Voidable contracts can be confirmed. Confirmation extinguishes the action to annul a voidable contract. Article 1392. Confirmation is the proper term for curing the defect of a voidable contract. Confirmation cleanses the contract from all its defects from the moment it was constituted. Article 1396. Requisites of confirmation. 1. That the contract is a voidable or annullable contract. 2. That the ratification is made with knowledge of the cause for nullity. 3. That at the time the ratification is made, the cause of nullity has already ceased to exist. Confirmation may be effected expressly or tacitly. It is understood that there is tacit confirmation if, with knowledge of the reason which renders the contract voidable and such reason having ceased, the person who has a right to invoke it should execute an act which necessarily implies an intention to waive his right. Article 1393. D. Voidable contracts can be confirmed only by the party whose consent was vitiated. Confirmation does not require the conformity of the contracting party who has no right to bring the action for annulment. Article 1395. Confirmation may be effected by the guardian of the incapacitated person. Article 1394. 3 unenforceable contracts. Art. 1403. The following contracts are unenforceable, unless they are ratified. 1. Those entered into in the name of another person by one who has been given no authority or legal representation, or who has acted beyond his powers. 2. Those that do not comply with the statute of frauds as set forth in this number. In the following cases an agreement hereafter made shall be unenforceable by action, unless the same, or some note or memorandum, thereof, be in writing, and subscribed by the party charged, or by his agent. Evidence, therefore, of the agreement cannot be received without the writing, or a secondary evidence of its contents. A. An agreement that by its terms is not to be performed within a year from the making thereof. B. A special promise to answer for the debt, default, or miscarriage of another. C. An agreement made in consideration of marriage, other than a mutual promise to marry. D. An agreement for the sale of goods, chattels, or things in action, at a price not less than 500 pesos, unless the buyer accept and receive part of such goods and chattels, or the evidences, or some of them, of such things in action, or pay at the time some part of the purchase money. But when a sale is made by auction and entry is made by the auctioneer in his sales book, at the time of the sale, of the amount and kind of property sold, terms of sale, price, names of the purchasers and person on whose account the sale is made, it is a sufficient memorandum. E. An agreement of the leasing for a longer period than 1 year, or for the sale of real property or of an interest therein. F. A representation as to the credit of a third person. 3. Those where both parties are incapable of giving consent to a contract. Art. 1404. Unauthorized contracts are governed by Article 1317 and the principles of agency in Title X of this book. Art. 1405. Contracts infringing the statute of frauds, referred to in number 2 of Article 1403, are ratified by the failure to object to the presentation of oral evidence to prove the same, or by the acceptance of benefit under them. Art. 1406. When a contract is enforceable under the statute of frauds, and a public document is necessary for its registration in the Registry of Deeds, the parties may avail themselves of the right under Article 1357. Art. 1407. In a contract where both parties are incapable of giving consent, express, or implied ratification by the parent, or guardian, as the case may be, of one of the contracting parties shall give the contract the same effect as if only one of them were incapacitated. If ratification is made by the parents or guardians, as the case may be, of both contracting parties, the contract shall be validated from the inception. Art. 1408. Unenforceable contracts cannot be assailed by third persons. An unenforceable contract is a contract which cannot be enforced by a proper action in court, unless they are ratified. Because either they are entered into without or in excess of authority, or they do not comply with the statute of frauds, or both the contracting parties do not possess the required legal capacity. The following contracts are unenforceable unless they are ratified. Article 1403. Those entered into in the name of another person by one who has been given no authority or legal representation, or who has acted beyond his powers. Art. 1317. No one may contract in the name of another without being authorized by the latter, or unless he has by law a right to represent him. A contract entered into in the name of another by one who has no authority or legal representation, or who has acted beyond his powers, shall be unenforceable, unless it is ratified, expressly or impliedly, by the person on whose behalf it has been executed, before it is revoked by the other contracting party. When a person enters into a contract for and in the name of another, without authority to do so, the contract does not bind the latter, unless he ratifies the same. The agent, who has entered into the contract in the name of the purported principal, but without authority from him, is liable to third persons upon the contract. The proper term for this case is ratification. Example, in a sale, Y claimed that he was an agent of X, even if not. The contract cannot be enforced against X. Another example is when the agent is authorized to lease the property but the agent instead sells the property. The principal is not bound. B. Those that do not comply with the statute of frauds. This is the most famous variety. I. An agreement that by its terms is not to be performed within a year from the making thereof. In Babeo vs. Perez, the Supreme Court interpreted the phrase, not be to performed within a year, to mean that the obligation cannot be finished within 1 year. Professor Balain does not agree with this interpretation. According to Professor Balain, the phrase, not to be performed within a year, should mean that the obligation cannot begin within a year. For practical reasons, the contract must be in writing since the parties might forget. This rule was made to guard against fallibility, forgetfulness, of man and fraud. According to Professor Balain, the Supreme Court's interpretation is incorrect. If the obligation cannot be finished within 1 year, the contract is not within the statute of frauds because of partial performance. 2. A special promise to answer for the debt, default, or miscarriage of another. The test as to whether a promise is within the statute has been said to lie in the answer to the question whether the promise is an original or collateral one. If the promise is an original one or an independent one, that is, if the promisor becomes thereby primarily liable for the payment of the debt, the promise is not within the statute. If the promise is collateral to the agreement of another and the promisor becomes merely a surety or guarantor, the promise must be in writing. 3. An agreement made in consideration of marriage, other than a mutual promise to marry. A mutual promise to marry does not fall within the statute of frauds since they are not made in writing. Agreements made in consideration of marriage other than the mutual promise to marry are within the statute of frauds. In Cabag vs. Auxilio, the father of the groom promised to improve his daughter-in-law's father's house in consideration of the marriage. The father of the groom made improvements on the house. The wedding did not take place. The Supreme Court said that the father of the groom could not sue on the oral contract which as to him is not mutual promise to marry. Professor Balain disagrees with the Supreme Court. According to Professor Balain, the father of the groom should be able to sue since there was partial performance. 4. An agreement for the sale of goods, chattels, or things in action, at a price not less than P500, unless the buyer accepts and receives part of such goods and chattels, or the evidence, or some of them, of such things in action, or pay at the time some part of the purchase money. But when a sale is made by auction and entry is made by the auctioneer in his sales book, at the time of sale, of the amount and kind of property sold, terms of sale, price, names of the purchasers and person on whose account the sale is made, it is a sufficient memorandum. The requirement of a written instrument or a memorandum for sales of personal property for a price not less than P500, covers both tangible and intangible personal property. It also covers the assignment of choses in action. Where a contract for the sale of goods at a price not less than P500 is oral, and there is neither partial payment or delivery, receipt, and acceptance of the goods, the contract is unenforceable, and cannot be the basis of an action for the recovery of the purchase price, or as the basis of an action for damages for breach of the agreement. Where there is a purchase of a number of articles which taken separately does not have a price of P500 each, but taken together, the price exceeds P500, the operation of the statute of frauds depends upon whether there is a single inseparable contract or a several one. If the contract is entire or inseparable, and the total price exceeds P500, the statute applies. But if the contract is separable, then each article is taken separately. V. An agreement of lease for a period of more than 1 year, or the sale of real property or of an interest therein. As long there is a sale of real property, the sale must be in writing. There is no minimum. An oral contract for a supplemental lease of real property for longer period than 1 year is within the statute of frauds. An agreement to enter into an agreement is also within the statute of frauds. 6. A representation is to the credit of a third person. A wants to borrow money from C does not know A. C goes to B to ask about A's credit standing. B says that A's credit standing is satisfactory even though B knows that A is insolvent. Under Article 1403, C can go after B if B's representation was in writing. Professor Balain thinks that this does not belong in the statute of frauds. There is no contract between C and B. B did not bind himself to pay C. What we have here is an unenforceable tort. According to Professor Balain, a representation as to the credit of a third person should be replaced by Article 1443. Article 1443 provides that no express trusts concerning an immovable organ any interest therein may be proved by parole evidence. When the express trust concerns an immovable or an interest therein, a writing is necessary to prove it. This writing is not required for the validity of the trust. It is required only for purposes of proof. When the property subject to the express trust, however, is not real estate or an interest therein, then it may be proved by any competent evidence, including parole evidence. See those where both parties are incapable of giving consent to a contract. Neither party or his representative can enforce the contract unless it has been previously ratified. The ratification by one party, however, converts the contract into a voidable contract, voidable at the option of the party who has not ratified. The latter, therefore, can enforce the contract against the party who has ratified. Or, instead of enforcing the contract, the party who has not ratified it may ask for annulment on the ground of his incapacity. The proper term is acknowledgement, and not ratification. Two principles in the statute of frauds. A parole evidence is not admissible. However, there are two ways of bringing it out. Two ways in which parole evidence is admissible. I. Failure to object by the opposing lawyer when parole evidence is used, Article 1405. If there is no objection, then parole evidence is admitted. 2. Acceptance of benefits, Article 1405. If there has been performance on one side and the other side accepts, then the statute of frauds is not applicable. Also, estoppel sets in so by accepting performance, the defect is waived. B. The statute of frauds applies only to executory contracts and not to those which have been executed in whole or in part. Executed here means there has been performance in part and acceptance by the other. For void contracts. Art. 1409. The following contracts are inexistent and void from the beginning. 1. Those whose cause, object, or purpose is contrary to law, morals, good customs, public order or public policy. 2. Those which are absolutely simulated or fictitious. 3. Those whose cause or object did not exist at the time of the transaction. 4. Those whose object is outside the commerce of men. 5. Those which contemplate an impossible service. 6. Those where the intention of the parties relative to the principal object of the contract cannot be ascertained. 7. Those expressly prohibited or declared void by law. These contracts cannot be ratified. Neither can the right to set up the defense of illegality be waived. Art. 1410. The action or defense for the declaration of the inexistence of a contract does not prescribe. A void contract is an absolute nullity and produces no effect, as if it had never been executed or entered into. The following contracts are inexistent and void from the beginning, Article 1409. A. Those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. B. Those which are absolutely simulated or fictitious. C. Those whose cause or object did not exist at the time of the transaction. According to Professor Balain, Article 1409, 3, should not be, did not exist. Rather, the correct phrase should be, could not come into existence, because there can be a contract over a future thing. Examples of, could not come into existence, are tangerine flying elephants and cars running on urine. D. Those whose object is outside the commerce of men. E. Those which contemplate an impossible service. Here, there is no object. F. Those where the intention of the parties relative to the principal object of the contract cannot be ascertained. This is similar to being void for vagueness under the constitutional law. G. Those expressly prohibited or declared void by law. An example of this is sale between husband and wife, subject to exceptions. The Supreme Court has held that contingent fees of lawyers wherein the latter receive part of the property subject of litigation are valid, unless unconscionable in amount. Characteristics of void contracts. The contract produces no effect whatsoever either against or in favor of anyone. B. A judgment of nullity would be merely declaratory. There is no action for annulment necessary as such as ipso jure. Even when the contract is void or inexistent, an action is necessary to declare its inexistence, when it has already been fulfilled. Nobody can take the law into his own hands. The intervention of a competent court is necessary to declare the absolute nullity of the contract and to decree the restitution of what has been given under it. The judgment of nullity will retroact to the very day when the contract was entered into. C. It cannot be confirmed, ratified, or cured. D. If it has been performed, the restoration of what has been given is in order, except if peri delicto will apply. E. The right to set the contract's nullity cannot be waived. F. The action for nullity is imprescriptible, Article 1410. As between the parties to a contract, validity cannot be given to it by estoppel if it is prohibited by law or is against public policy. G. Any person can invoke the contract's nullity if its juridical effects are felt as to him. The defense of illegality of contracts is not available to third persons whose interests are not directly affected, Article 1421. Peri delicto, an equal guilt. Art. 1411. When the nullity proceeds from the illegality of the cause or object of the contract, and the act constitutes a criminal offense, both parties being in peri delicto, they shall have no action against each other, and both shall be prosecuted. Moreover, the provisions of the Penal Code relative to the disposal of effects or instruments of a crime shall be applicable to the things or the price of the contract. This rule shall be applicable when only one of the parties is guilty, but the innocent one may claim what he has given, and shall not be bound to comply with his promise. Art. 1412. If the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, the following rules shall be observed. 1. When the fault is on the part of both contracting parties, neither may recover what he has given by virtue of the contract, or demand the performance of the other's undertaking. 2. When only one of the contracting parties is at fault, he cannot recover what he has given by reason of the contract, or ask for the fulfillment of what has been promised him. The other, who is not at fault, may demand the return of what he has given without any obligation to comply his promise. Articles 1411 and 1412 refer to the peri delicto rule, which literally means, an equal kind, or also, an equal guilt. In peri delicto oritur actio and sometimes, in equal guilt, the position of the defendant is stronger. In peri delicto potier est conditio defendentis. The position of the defendant is stronger because the plaintiff's claim is not really granted. The peri delicto rule applies only to contracts which is void for illegality of subject matter. Thus, if the contract is void for simulation, the peri delicto rule does not apply, so a party can claim the object back through reconveyance. Outline. A. If it constitutes a criminal offense. I. If both parties are in peri delicto. No action for specific performance can prosper on either side, Article 1411, first. No action for restitution can prosper on either side. Article 1411, first. Example, a shabu supplier supplies shabu to the shabu dealer. If the shabu supplier does not deliver the shabu, the dealer cannot file an action for specific performance. 2. If only one party is guilty. No action for specific performance can prosper on either side. An action for restitution will be allowed only if the innocent party demands. The guilty party is not entitled to restitution. B. If it does not constitute a criminal offense. A. If both parties are in peri delicto. No action for specific performance can prosper on either side, Article 1411, first. No action for restitution can prosper on either side. Article 1411, first. 2. If only one party is guilty. No action for specific performance can prosper on either side. An action for restitution will be allowed only if the innocent party demands. Exceptions to pari delicto. A interest paid in excess of the interest allowed by the usury laws may be recovered by the debtor, with interest therefrom from the date of payment, Article 1413. B. When money is paid or property delivered for an illegal purpose, the contract may be repudiated by one of the parties before the purpose has been accomplished, or before any damage has been caused to a third person. In such case, the courts may, if the public interest will thus be subserved, allow the party repudiating the contract to recover the money or property, Article 1414. C. Where one of the parties to an illegal contract is incapable of giving consent, the courts may, if the interest of justice so demands, allow recovery of money or property delivered by the incapacitated person, Article 1415. D. When the agreement is not illegal per se but is merely prohibited, and the prohibition by law is designed for the protection of the plaintiff, he may, if public policy is enhanced, recover what he has paid or delivered, Article 1416. E. When the price of any article or commodity is determined by statute, or by authority of law, any person paying any amount in excess of the maximum price allowed may recover such excess. Article 1417. F. When the law fixes, or authorizes the fixing of the maximum number of hours of labor, and a contract is entered into whereby a laborer undertakes to work longer than the maximum thus fixed, he may demand additional compensation for service rendered beyond the time limit, Article 1418. G. When the law sets or authorizes the setting of a minimum wage for laborers, and a contract is agreed upon by which a laborer accepts a lower wage, he shall be entitled to recover the deficiency, Article 1419. The above contracts are void but there is some remedy for policy considerations. An example is the minimum wage law under Article 1419 wherein the employer and the employee freely agree to the terms of employment below the minimum wage. Although they are in pari delicto, you don't follow the rules of pari delicto. There is a policy consideration of social justice involved. This is similar to the preferential option for the poor of churches. Final provisions. Art. 1420. In case of a divisible contract, if the illegal terms can be separated from the legal ones, the latter may be enforced. Art. 1421. The defense of illegality of contract is not available to third persons whose interests are not directly affected. Art. 1422. A contract which is the direct result of a previous illegal contract, is also void and inexistent. Dear fellow bar examines, I'm sorry the editing of this reviewer took longer than I expected. I hope this reviewer would help you make sense of the rather confusing world of civil law. The notes here are from Professor Ruben F. Ballane's lectures in his Up Civil Law Review class. I'm not sure from what year. I just added the codal provisions and reformatted the notes for easier reading. I also included parts of the Obligations and Contracts reviewer made by 4A Class 2000 in my notes in Civil Law Review 2 on Obligations and Contracts, also under Professor Ballane, last semester, 2001 to 2002. If you find this helpful, please share with another examinee. If you see any mistake, please share with me. Thanks. God bless and good luck to all of us. Ateneo Law 2002. Thank you to Professor Ruben F. Ballane.